Scottish ministers to consider this wind farm application and to report back to the ministers. My colleague, Mr. Keith Bray, has also been co-appointed alongside me, who I'm aware that you're well aware of. An agenda for today's hearing was issued on the 17th of August in 2026, so I hope you've all received this and have it at hand. The virtual session is being broadcast live, and as with previous sessions, by taking part today, you're consenting to being filmed and to the use and storage of those images and sound recordings and any information contained within them for webcasting and training purposes, and for the purpose of keeping historical records and making those records available to the public. So I think at this point, can I ask, please, that the parties introduce themselves? If we could begin with the applicant.
Good morning, sir. Yes, thank you. My name is Marcus Trinnick. I'm a solicitor at King's Counsel. I'm instructed by Lizzie Tainch of Wright Johnson Mackenzie, who you will see on the call. And I'm also accompanied virtually by Richard Wild, the Project Development Manager at Coriolis for Dell 2. Thank you.
Thank you. Okay, can we move on to the council, please?
Good morning. My name is Francesca Glendinning, advocate for the Highland Council. I'm accompanied today with Peter Whelan and Colin Ross.
Thank you very much. Okay, can we move on to the Community Council, please?
Good morning. My name is Mark Hindley, Stratherick and Foyers Community Council.
Thank you. Nature Scott, please.
Good morning, sir. My name is Peter Ferguson. I'm a solicitor with Harper McLeod, and with me virtually are Karen Wren-Toole, who is a policy and advice manager, and Claire Davidson, who is an operations officer with Nature Scott. Thank you.
Thank you very much. SEPA, please. Okay, nobody here from SEPA yet?
Excuse me, sir. I think there was correspondence from SEPA that said that we're just resting on written submissions and wouldn't be participating today.
Right.
As far as I understand it.
Must have missed that. Thank you very much.
Thank you.
Okay. Finally, representatives of Strawn-Lairg Wind Farm.
Good morning, everybody. My name is Carolyn Wilson. I'm the Head of Onshore Consents and Environment for SSE Renewables, and I'm accompanied today by my colleague Grant Henderson from Strawn-Lairg Wind Farm, who's the MSA Services Manager for Strawn-Lairg. Thank you.
Thank you very much. Okay, moving on. The purpose of this morning's hearing session is to examine matters raised in relation to the proposed list of conditions and submissions thereafter. However, I will not go over ground that is agreed, and where I consider that further information is not required for me to prepare my report, I will not go over that ground. I shall lead the discussion by starting off each agenda item by directing a question at one of the parties. After the answer, I shall invite other parties to comment. If you have comments or questions as the discussion progresses, please make sure these go through me and let the other parties finish their point. Even if you strongly disagree about what is being said, please don't interrupt the other parties. I will leave it up to each party's main spokesperson to decide who answers the questions for them. The spokesperson may also wish to add some concluding remarks to certain points. Excuse me. These should be focused and brief where possible, please. Please remember to switch your microphone off if you're not speaking. Please have the documents to hand and refer to the document number and the electronic page and paragraph number if you're making references. Please provide the references clearly and allow time for everyone to get the documents up on their respective screens. When I consider that I have the information that I need to write up my report, I will move on to the next item. Don't feel obliged to comment if you're only repeating what has already been said or included in written material before me. Excuse me, I've got a bit of a cold today, so you might be hearing a lot of this, guys. Sorry. All that you tell me today is evidence that may need to be included in my report, and you will see me take notes. Excuse me. Apologies. At times, I might ask you to pause so that I can catch up with my notes. I expect that matters set out in the agenda will be dealt with during the course of this afternoon. I intend to use the table of conditions as submitted by the applicant on the 7th of August 2026, and I will work through these as numbered in the table. It would be helpful if parties have this to hand. You will see from the agenda that I intend to consider the Section 36 conditions first, then the deemed planning consent conditions, and finally the additional conditions. Just a point, I note from the table of conditions submitted by the applicant that everything was labelled as a Section 36 condition. I've assumed that this is just a formatting error within the table, and the conditions 1 to 5 are Section 36 conditions, with the rest being deemed planning conditions. Can I ask the applicant just if this assumption is correct?
Sorry, yes, sir.
I'll leave. I should say that Lizzie Tainch will do most of the talking this morning, so I will keep quiet and let her speak.
Thank you, Mr. Trinick. Yes, apologies. Yeah, it just appears that it's been sort of a formatting matter that's gone all the way through the conditions. But yes, it's as you said there. Thank you.
Excellent. Thank you. One point to note, where I have used the terms agreed or disputed in the agenda, this refers to the status between the applicant and the council as per submitted in that table. It's not a reference to their status with other parties, and it's not a reference to how the reporters view them. So where you see not in dispute, that it's just essentially the status in the table as submitted. Likewise, can I ask all parties if they're happy, there have been a late flurry of submissions in advance of today's hearing. Can I ask if the parties, if they're happy that we accept both the council's submission of their additional comments on that condition statement? Are all parties happy to accept that?
Yes.
Okay, thank you. And likewise, can I ask all parties if they're happy that we accept the applicant's submission of the two documents relating to Cairnmore Hill Wind Farm and the Kalaki Wind Farm?
Yes.
Nodding heads. Thank you very much. I know there's been some additional emails which I've just seen this morning, but we can come to those at the appropriate stage on today's proceedings. One last thing, can I check that everybody has a copy and has seen a copy of the Community Council's recently submitted comments also? Okay, thank you very much. So before we progress to item 2 on the agenda, does anybody have any procedural questions at this time? Excuse me. Okay, I'll take that as a no. Thank you very much. Okay, item number 2 on the agenda, you will see relates to the potential legal agreement and discussion round about concerning Stronlairg Wind Farm. Now, based on the recent correspondence from Stronlairg and the applicant, some of which, as referenced, I've just seen this morning, can I ask that the applicant please provides us an overview of where we are at in those discussions, please?
Thank you, sir. Yes. As noted in email yesterday, it's clear that the applicant and SSE have been talking at cross purposes. SSE is addressing the impacts of wake turbulence on its turbines at Stronlairg, while the applicant's been responding in terms of potential losses of yield because of the distance between Dell 2 turbines and Stronlairg turbines. And that's in further written submissions. We'll see it's covered so far in documents 315 to 320. Now, the applicant accepts responsibility for this confusion, and I'm sorry it's happened. I note from the very recent emails that SSE has agreed to provide the technical report which led to the objection, or at least a technical report, whatever it is. If that report reveals a proper basis for SSE's concerns, then I acknowledge that may well be a material consideration, as opposed simply to loss of yield, which we say is not. Now, if it is necessary to deal with matters on that basis as a material consideration, it would seem best to address them by a bilateral interface agreement, a bilateral agreement between the applicant and SSE. Now, in terms of your position on this matter, if you decide the topic is a material consideration, you will need to decide what can be secured by condition or agreement. I don't wish to try to draft a condition on the hoof today, but want to have more time, if the SSE report demonstrates the need to do so, to work up a condition in discussion with SSE and then submit that in hopefully agreed form, and I ask for an initial 3-week period following receipt of the SSE report to consider matters before reporting to you. Thank you, sir.
Thank you, Mr. Trinick. Can Stranraer or do Stranraer SSE wish to make comment on that?
Yes, yes. We would wholly accept that position from the applicant and would be more than happy. As I say, unfortunately, I was on annual leave and only picked up the request for the report. We don't have it in a report format as such. It was a series of assessments that were undertaken over a period of time, leading to our original representation at the time of the application being considered by the ECU. So these are in a series of various assessments and not in a report format. However, we've gone back to our energy analytics team and we will get it in a report format that is, a technical report format that can be considered by the applicant. And we would be more than happy to enter into discussions. We did have some discussions with the applicant during the consideration of the application about our concerns and about various matters. So we would be more than happy to continue to discuss this issue with the applicant if as Mr. Trinick says, it's found to be, and the applicant agrees that it is found to be material by yourselves, and the applicant appreciates that there is an adverse impact. We would be more than happy to continue those discussions and agree a suitable condition if that was that your intended way forward on this. So yeah, I don't think there's, Grant, is there anything else you want to say in respect of that? But I think that's an appropriate way forward from our perspective.
Yeah, absolutely. It's appreciated that the applicant has sort of highlighted that issue. I think we made clear right from the start that our issue here is, and our representation has never been based upon loss of revenue. It's more the potential impact upon, the material impact upon the integrity of our turbines and what that brings with it in terms of fatigue, damage, safety, operational movements, etc., etc. This is not a representation based upon loss of income, which would be, wouldn't be a fair representation. So yeah, in terms of the report, I think we can pull that together relatively quickly, and keen to get that across to the applicant and their representatives as soon as possible. I'm more than happy to enter into discussion if they have any queries upon what we present.
Okay, thank you very much. Do the council have any comments to make on this matter in terms of the potential for a legal agreement as discussed?
The council doesn't have any comments to make. Thank you, sir.
Thank you very much. Mr. Bray, do you have any questions or comments on this matter?
It would certainly seem to me that given what the applicant and Stranraer Wind Farm has said today, that there is a requirement for further procedure. I'm not sure I'm content with information that should be with us just been circulated to the applicant. But if I could ask Stranraer Wind Farm whether or not any information in that would be sensitive in any sort of way.
No, none of it would be sensitive, and we would submit it formally. I think when Mr. Henderson said he'd submit it to the applicant, we'll submit it formally to the inquiry, and obviously copy it to the applicant and all parties. There would be nothing particularly sensitive in that. It's a lot of it is very technical, obviously, and our engineer that prepared it, Michael Watt, as outlined in our original, in our correspondence, is more than happy to appear in front of parties or answer further technical questions if there is anything that needs clarified in terms of that report and assessment when we submit it.
And would you have a time scale that you could give us today in terms of when that piece of work could be complete?
I would hope within the next week. Grant, would that be? Yeah, we obviously have to we have a lot of the information to hand. It's just not, and the assessments have all been done. We would just need to ask our colleagues in the energy analytics team to present it in a kind of readable report format with you know, maybe their technical assessments as appendices or something like that. But as I say, they are happy to talk to those technical assessments if required.
And therefore, if we as the reporters were to require that information through, if you like, a procedure notice, with a period of 2 weeks, because we might ask for the report and ask supplementary questions, would a period of 2 weeks seem reasonable to you?
Yes, it would, sir. Yes.
Okay. Well, it'd be useful to get the applicant's view on whether they have any thoughts on what I just said, is that we would ask for the information formally. We may have any supplementary questions around planning conditions and materiality and such like to put to a strong first of all, and then allow the applicant a period of 3 weeks after that to come back on the assessment and the responses to any questions that we have. And if you like, that would be treated as a normal further written submissions procedure. If there is anything outstanding with regard to that, then I think these could be dealt with in what we agree with closing submissions. Just not 100% comfortable about a mini inquiry happening in the background. I would prefer rather these things be done in the full light of day. So, Mr. Trinick, do you have any comments on that? Introducing a fresh further written submissions request from the reporters and allowing the applicant to respond.
No, sir. That seems absolutely fine and very fair, and we accept that.
So 2 weeks and 3 weeks, I think that fits in with what we've heard, and then anything outstanding for closing submissions. Okay, I think that's probably as far as we need to go today. We'll obviously be allowing other parties as well to comment, but in particular the council. I think it'd be useful for the council to have their say. Okay, Mr. Bryans, I think that's all I've got to say on that matter, unless any other parties got anything else before we move on.
Okay, we will move on to item 3 then on the agenda. Again, there's been a bit of a flurry of kind of late correspondence on this. Can I ask the applicant to please provide an update on the current position with respect to watercourse crossings regarding the construction track access track, bridge design, flood risk appraisal? Please provide an update.
Yes, sir. So over the course of the past while, the applicant, council and SEPA have been discussing what further work is required in terms of the appraisal and things, and an updated appraisal has been presented to SEPA and Highland Council. As of I believe Friday, a response came from SEPA to yourselves as well as the parties, indicating that they were content or largely content with the content of the updated appraisal, and that the measures in there address the impacts that they see, and the rest can be left sort of post-consent matters. That to allow them to remove their objection to the application, subject to condition. The applicant responded to that yesterday following consideration of their proposed condition. And I set out in my email yesterday. Yeah, we've considered it. We don't feel that the condition is sort of acceptable in its format that's been put forward by SEPA. However, given that SEPA aren't here today, I don't believe that we should be sort of discussing going into the condition wording itself. I think that'd be a bit unfair without them here. So I suggest a period of maybe 2 weeks to allow discussions to continue between the applicant and SEPA and Highland Council, and seek to provide the reporters with either an agreed condition or otherwise a clear statement of the parties' respective positions on that matter.
Can I ask the council, do you have any comments on that position from the applicant?
Thank you, sir. The council are content with the applicant's suggestion that essentially discussions are taken offline for a period of a couple of weeks. Given that SEPA aren't represented this morning, it seems appropriate.
Sorry, Ms. Sani, what aspects in particular of the proposed condition from SEPA is it that you're particularly unhappy with?
The condition sort of as put forward in 23, it goes into quite a lot of detail in terms of policies for MPF4 and sensitive receptors and things that are mentioned within it. It's the applicant's position that the plan will be provided, or the condition as presently drafted allows for the plan to be implemented as approved, and that provides the mechanism which allows for the final designs to be subject to scrutiny and approval by the council as part of discharge before the works proceed. The applicant considers that as a sort of more appropriate approach instead of references to sort of specific policies, planning policies and individual receptors and similar.
Okay, just a point of clarification. The updated, obviously we haven't seen the updated appraisal assessment, but what design is that based on? Is it based on the design that we have submitted or the one that was previously spoken about and then not formally submitted?
So I'll ask my colleague Richard. He's the one that's more sort of deeply ingrained in the bridge design and the process to pick up on this one. Thank you, Richard.
Sure. So it's the one in closer to the original EIA design, but with some differences on the track leading up and the culverts.
Okay, and can I ask the applicant how they would anticipate this design, if it differs from the one that we have submitted, how they would anticipate this being treated as part of the inquiry?
Yeah, I suppose that's because the original one was advertised. If it's acceptable to the reporters, I suggest that it could be sort of lodged under Regulation 20 as a sort of information provided for the purposes of the inquiry. Given that it largely relates back to material that was provided previously and it's been represented. But again, Marcus, if you've got any comments on that?
I'm not yet convinced that what is now being produced is necessarily environmental information which would normally require to be advertised. I'm not convinced of that. However, to avoid any later difficulties, it would seem sensible to treat the material as AI and to make a request under Regulation 20 that it's information required for the purposes of the inquiry.
And do you have a time period, Mr. Trinity, if that was requested of you, along, I assume that would be along with any updated flood risk assessment that I think was referred to. Does that need to be over a two-week period, or could that be quicker?
I'll hand over to Lizzie.
Thank you. Yes, the material, to the extent that SEPA are happy with it, has already been presented. It's before the parties. I sent it to the case officer yesterday, along with my email. So I think within the next 24, 48 hours, it could be published. It could be advertised, subject to advertising.
But may not need
So
to
it could be, no, it could, sorry, apologies, if it's under Regulation 20, then yep, it's provided SEPA are happy with it and it's agreed form. So I'd suggest that I could just double check that with SEPA following the hearing today. And then that can be completely finalised and be ready.
Yeah, there's a reason why Mr. Brands didn't mention that document with regard to accepting the other documents in. It was to allow this discussion first. So I think I would be quite content, subject to other parties' comments, that we were requested that information, and if that can be provided formally quite quickly, as you said, we would probably ask for a further written submissions procedure again around the parties' views around conditions, and try to conclude it through further written submissions. What happens in the background, that's possibly a matter for the parties, but I think we've got to formally capture it as part of the kind of procedures. So we'd be probably looking for the information to be submitted, as you said, under the necessary regulations, for parties to comment on it with a draft condition, and to come back with comments. What it might be useful to get is a flavour from the applicant whether you would think it more appropriate to ask for a draft condition from the applicant or from SEPA. Mr. Trinnick, I don't know if you've got a view on that. What would be the best approach from our perspective? Or would we just ask you collectively to put your positions together in terms of trying to achieve a agreed condition within a certain time?
So my preference would be that we promote a condition to SEPA for discussion and then try to bring you an agreed condition.
Okay. So our further written submission would be essentially asking for your position on whether a condition is agreed or not. So I think that would be the way to go forward on that one. I'm not sure if the council's got any comment about, if you like, that procedure, additional information for the purpose of the query, and then a very short further written submissions procedure that they've been involved in order to discuss the condition. The council.
The only point that the council would wish to make was that any additional information which is submitted in relation to the updated design should be advertised. I think the suggestion was that it would just be submitted for the purposes of the inquiry, but the council's view is that probably should be publicised.
And can you explain the reasoning for that? I mean, we can obviously take a view on that after the meeting, but is there any particular reason why?
I'm Keith. From looking at the information presented by the applicant in the latest design, there is a receptor downstream. It's relatively close to the bridge crossing, and the modelling work suggests that the flooding event comes relatively close to that property, in fact very close to that property, and therefore not advertising it and not having awareness of what is being proposed seems to be unreasonable.
From the applicant's point of view, do you want to respond to that?
So yes, we've been through the opt-in process for the inquiry, and the issue has been there since the opt-in process. Therefore, only those who have opted in will be in a position to make representations on what is received, and therefore I think the Regulation 20 process is perfectly adequate for the occasion.
Well, I think that we probably need to just take that matter away and come to conclusion that on that quickly. If it is to be advertised, it obviously best a more elongated process. If we conclude it can be requested for the purpose of inquiries, then we would proceed on the basis that that we discussed, but I think we'll just have to take that away and come to a conclusion swiftly in that, unless Mr. Brown's has got any other ideas.
No, I think we'll need to take this away and have a think about it ourselves, Mr. Brown.
And I think we'll be able to come to a conclusion on that matter quite quickly.
Okay, unless there's any more comments on this matter, I think we will move on to part 4 of the agenda. Any more comments or any more issues to be raised? Nope. Okay, moving on to part 4 of the agenda with respect to a multi-stage condition. I'm going to hand back to Mr. Bray for this part of the agenda.
Yeah, there was a draft conditions prepared, and it was put in the agenda so everyone could see it. I think the applicant has provided commentary on that and an alternative condition. This condition would only be required if ministers were to conclude that the wind farm and its grid connection are found to be a single project. We haven't reached a conclusion in terms of our recommendations as yet, and ministers have obviously not considered it. So it's only in that event, in order that the significant effects or any likely significant effects are taken into account before any consent for any part of the project is to proceed. So the fact that the condition is there it doesn't reflect our conclusions. However, I think the applicant has provided commentary on that draft condition. I think that was yesterday's email of 16:13, I think, Stanish, and given it came in fairly late, I'd just like to kind of ask the applicant just to explain their position with regard to that email and suggested changes to the condition, and then we'll maybe come along to the council and other parties after that. So I don't know if that's Mr. Trinick or
Yeah, thanks. So it's me. Responding to what you said just then, I think there is 2 stages. The first stage is, as you say, for the decision maker to decide if the generation plant and the grid are a single project for EIA purposes. But there is a second stage before you come to consider a condition, and that is whether or not you already have adequate, competent EIA of the in-combination effects of the wind farm and the grid. And you will know from our FWS documents 340, I think it is, paragraph 10 thereabouts and following, it's our position that, first of all, yes, we are a single project for EIA purposes, and secondly, we have provided competent EIA of those in-combination effects. If you accept that, then even though it may be a single project for EIA purposes, a condition would not be required or appropriate. However, if you decide that the information you have is not a competent EIA in the terms I've discussed, then you will need to impose a condition. We looked at the one in the agenda. That condition was actually imposed as condition 25 on the Caremore Hill written appeal decision issued on the 27th of June 26. It's now been sent to you. No need to go there, obviously, but for those who want to look, it's on electronic page 46, condition 25. So I can see why that's the starting point. The condition we sent through yesterday, people have got the wording in front of them, actually is in substance more or less the same as that imposed on Caremore Hill. It envisages the same process. But the only difference is that we've added an ability to carry out site investigations without commencing development. And we've defined what site investigations mean. It's basically a geotechnical and geophysical investigation, not involving intrusive development except for coring. So that's the reason we put forward the gloss on the Caremore Hill decision, and I'm happy to discuss it.
Thank you, Mr. Trent. I accept, if you like, your summary of the stages that I didn't, if you like, suggest a wee minute ago. Before I open up, though, I would want to ask, I mean, the draft set of conditions at the end of the draft set of conditions have got a set of definitions. And I was just wondering why in that particular condition you would wish to have safer site investigations included, and there's quite a number of other conditions that probably say no development shall commence until X, Y, and Z. So if there was a agreement that site investigations were to be inserted into the definitions, for want of a better phrase, there would be no need for that to be in that condition. It'd be useful just to get the applicant's thoughts on that. I think towards the end of the table, as submitted, I think there are a set of definitions. But I don't think commencement of development is defined, but I don't think that there is anything with regard to site investigations. There is site enabling works, but it would just seem if you were requesting it for that condition, it would be strange why you weren't requesting it for all the other conditions. So I'm just wondering if there's an easier way to deal with it, Mr. Trinick.
I looked at that yesterday, sir. The difficulty with the two relevant definitions, which are permitted preliminary works and site enabling works, is that they relate to specific other conditions and they're required for that purpose. Indeed, the site enabling condition is an ECU standard condition. However, both those definitions involve development. In case of permitted preliminary works, the provision of a temporary contractor's facilities, and in the case of enabling works, works going beyond how I have defined site investigations. And I felt that it would be inappropriate to try and use either of those definitions to achieve the purpose intended. All that we want is to be able to do geotechnical and geophysical investigations, not to provide temporary facilities within the site or carry out any other works.
Okay, I think maybe I'll reword the question. Why is it important with regard to that condition as opposed to the other conditions that say there'll be no commencement development until X, Y, and Z are submitted?
Well, we don't want to ask for too much, it's as simple as that. I could see resistance to any definition to using one of the other definitions, say for permitted preliminary works or say for site enabling works. And that is why I drafted it as I did. If you feel it's appropriate to fall back on an existing definition, subject to other parties' views, then, well, we're more than content because it enables us to do rather more.
No, I think my initial comments were whether or not you're wanting to add a definition into the existing set of definitions, which are fairly standard. But before we do that, I think it may be useful to get the planning authority's view, as they may well be the experts with regard to when development has commenced and such like. So any thoughts from the council on what you've heard?
Thank you, sir. The council would propose that any multi-stage condition which is imposed follows the style or the wording which was used in the recent Ben Akatil wind farm case. I understand that that was put to the applicant yesterday. I'm not too sure if that position has been communicated to the DPA, in which case I'm not too sure, unfortunately, whether you yourself have the wording of the council's proposed condition. If I could maybe check that in the first instance.
I'm probably not in a position to say whether we've received it because I can't recall from the applicant's point of view. Do you recall if it's been circulated more widely? We've got the two decisions that you sent in.
Apologies. I've just confirmed that it hasn't been submitted to the DPA. I understand that it was raised in correspondence with the applicant yesterday following the decisions which the applicant has submitted in respect of their proposed approach. I don't know if it would be of assistance for me to set out the terms of the condition or that to be emailed in, whether or not the reporters have a preference in that respect.
I think it would be useful just to have your views in the first instance on what the applicant has proposed, and my commentary around asking why that condition required a definition of site investigation works as opposed to other conditions. So it's just your thoughts on that in the first instance.
In the first instance, the council's thoughts on the applicant's proposed draft are that it should be framed slightly more widely insofar as who the discharge of the condition is ultimately left to in terms of responsibility, insofar as it's not been determined yet whether or not the connection will be by way of underground cable or overhead line or a combination of both. I think potentially were discussed in the updated grid assessment, which was submitted a couple of months ago, in which case, if it was to be by way of an underground cable, then the planning authority would be the relevant authority in terms of the consenting route for that, and so should have a role in respect of the condition. In relation to the point about the applicant's desire to undertake site investigations prior to commencement of development, the council's, I suppose, primary position is that no work should be commenced until the impacts of that development have been fully assessed in connection with the grid connection.
Yeah, and from the applicant's point of view, do you think there's any benefit, if the council obviously feel that there's a benefit that we see another decision with perhaps an alternative wording? Your thoughts on that?
Thank you. Yes, I've seen the email exchange yesterday, which because WJM, Wright Johnson Mackenzie, were involved in Ben Akateel, and the exchange presupposed the knowledge of what happened at Ben Akateel. I wasn't involved. I haven't seen that condition. I can't comment. I have no objection, obviously, to you seeing the Ben Akateel condition. That's fine, and we can make observations on it. I'll just respond to Highland Council on a point there. Even if it's an underground connection, and therefore there will be a planning application to Highland Council for that connection, nevertheless, you are dealing with matters in a Section 36 context. And therefore, I think it's entirely appropriate that, per the Canmore Hill, the condition, or indeed the one we submitted, that the details of the grid should be approved by the Scottish ministers so as to provide that Section 36 link. That's why it's drafted that way. I believe that that's why the Canmore Hill condition was drafted. Well, not necessarily that way, because that was a TCPA application, but it's certainly appropriate for this one.
Okay, did the council have anything else further to say? I mean, have they been involved in any other recent decisions that the commencement of development is sought to be defined in such way?
I can't recall a case on the top of my head. However, well, the applicant is stating to try and refine the scope to site investigation works rather than site enabling works. I favour a separate definition if that's the route we were going to go down. However, as set out previously, we believe the site investigation works for the wind farm development should not take place until there is a consented grid connection for that wind farm. I also think the comments about who the consenting authority should be for the discharge of the condition, if the works relate to works that are governed by the Town and Country Planning Act, why would it be Scottish ministers and not the Town, not the planning authority? In practice, it shouldn't actually matter, because if you have a consent, there should be no reason why that condition couldn't then be satisfied.
So is your view that in terms of the draft condition that's under item 4, are you suggesting that the Scottish ministers should be substituted out for the planning authority?
If it's an underground cable connection. Yes.
That's an additional caveat you put in there, but in terms of that draft condition as drafted, do you have any proposed amendments to that condition, or would you prefer that we saw after the hearing the Ben Akdil decision, because that seemed to be the draft that you preferred?
I think in relation to any additions which would be required to the draft provided by the reporters for discussion this morning, it's perhaps a concern that at the moment the details of the grid connection could be slightly clearer, and the condition which was contained or agreed in the Ben Akdil wind farm case sets that out a bit more fully in relation to the information which is required to be submitted. So it may be of assistance if the Ben Akdil condition is provided for review.
If there's no objections from that document simply being lodged on its own without any comments, I'd be quite content with that. I don't think we'll be looking for commentary on that, but just simply submitted. If the parties are happy with that, then I see the Highland Council, I think we're nodding there. Does the applicant have any comment on that? The decision is submitted without commentary.
Well, so it's not a decision. No
Oh,
decision
right, okay.
has yet been made on Ben Akdil. These are simply post-inquiry submissions on the condition. That's what we're seeing. So nothing's been decided yet. I just would comment on Mr. Whelan's very fair point that you might substitute planning authority for Scottish ministers. That actually, I'm not sure I agree, because if it is an underground connection and you've got to stage of paragraph B that is received development consent, then they simply be approving what they've already approved, which doesn't make a lot of sense. The reason for the Scottish ministers being the appropriate body is precisely because this is a Section 36 application, and the ministers have ultimately to take the view on ratio issues.
Thank you, Mr. Ring. Sorry for misunderstanding perhaps the status of the Ben Akdil. I had assumed it was a decision. If it's not a decision that has been made, then I think it can be quite clear. I'm not looking for it as part of the inquiry. It's not been submitted in advance of this hearing, so there's obviously some discussion, but I'm not particularly interested in ongoing discussions in other cases unless it's a decision. I think we've had enough discussion as far as I'm concerned. I've heard from the council and the applicant. I don't know if there's any other party on the call or Mr. Bryan want to say anything else before we move on. No, I think we'll have enough based on the previous submissions, based on the discussion. We'll have enough to come to a conclusion in our report. So I think it's back over to you, Mr. Bryan.
Okay, thank you, Mr. Bray. We'll move on to item 5 on the agenda then. So the proposed conditions 1, 2, 3, and 4. I am satisfied that I have sufficient information on these conditions from the submissions made by the parties. Can I ask, do any parties have any matters that they wish to raise at this moment on those conditions? Okay, we'll move on to item 6 then on the agenda, and specifically condition 5 relating to compensatory planting. I note that this condition deviates somewhat from the standard section 36 condition. Can I ask the applicant, please, to explain their approach to the condition and the reason for deviating from the standard condition in the manner in which it has, please?
Yes, sir. The section 36 standard condition was used as a basis, and then the applicants. So you hear me okay? Yeah, thank you. Yeah, and then it's been sort of reviewed surrounding that to account for the forestry officer's position and the consultation response from Scottish Forestry, and then considered in light of the circular to account for that and the measures that are going to be put forward.
Okay, just specifically, I note that in section 1, for example, the standard condition reads no felling or development shall commence, including site and ground investigations. That's been amended to just simply no tree felling shall commence. Can you explain the thinking behind that, please?
Yeah, it's the applicant's view is, yeah, it's just to give it sort of further certainty that the preferred approach would be to specify trees as part of condition 1. Of course, it's up to yourselves.
To limit it specifically to tree felling. Sorry, in terms of specificity.
Yes, to add further specificity. As far as I understand it, Mr. Wild can correct me if I'm wrong, but I don't understand that there is any further felling beyond the tree felling that's intended or forms part of the application. Yeah, that's the case. And then the remaining details were just to add further details as per sort of the compensatory planting plan within part 1.
Okay, can I ask the council's views on this, please?
Yeah, and specifically in relation to part 1, if tree felling is stated, or if it just states felling, I'm not sure we have a preference. I don't personally see what the difference is, but for the rest of the condition, our comments have been circulated to parties in respect to the proposed amendments by the council. The forestry officer has confirmed that they wish to see productive planting to be put back on site, like for like, as per control of woodland policy removal. And I believe that's the point of contention to be addressed, and the comments from the forestry officer are there to be read. And then finally, the last point that seems to be overlooked in terms of the drafting of part H, the forestry officer also requires that the plan is implemented by a suitably qualified forestry consultant, and that has been included, but what's absent at the moment is details of the schedule of supervision and compliance monitoring, which is pretty standard.
Okay, just to start with, can I have the applicant's thoughts on the matter around the productive conifer planting and the inclusion or exclusion of silver birch, please?
Yes, sir. Since receiving the council's position on that yesterday, we've contacted our applicant's forestry consultant to discuss that further. He was on holiday, but since emailed this morning, so I think we can review sort of the position put forward by the council's forestry officer, sorry, and we can discuss that further offline internally. sort of following the hearing session today, with a view to provide sort of a revised condition.
And just looking to tidy that up in terms of procedures, would the applicant be happy that that could be dealt with in closing submissions? I'm just not wanting too many uncontrolled things happening here. So it sounds to me as if we were to ask for that in closing submissions, then that would seem reasonable to me. Does the council have any comment on that?
The council has no objection to that. Thank you.
Yeah.
Okay, and likewise, the applicant's comments on the council's proposed revisions to 2H.
Yep, similarly that, we've considered that internally, and I think generally looks, acceptable. But we'll, I think that should be okay. Accepted.
Okay, thank you. Does any other parties have any comments at this stage on condition 5?
I think, Mr. Brown, I just want to go back to the council that they could be content with a complementary planting condition which wasn't contingent upon being sorted before development commenced, but it was just before the first tree felling. If you're quite content with that.
That's our preference, that there's no filling that takes place until there's an agreed plan in place.
Well, that's slightly different to what you said earlier on. That's why I asked the question, is that I think you answered before that you were happy there was no tree felling, but now I think you're saying that you'd be happier if it was no development commencing, which is within the standard conditions. So you just want to clarify what your view is.
The wording that we're suggesting is that there is no tree felling or felling until the plan is approved.
Okay, so that wouldn't include a or development shall commence as per the standard condition. It's just simply about no felling. Okay,
that's right. So yeah.
That's clear. That's clear. Sorry, Mr. Brown, I just wanted to get that clear in my mind.
No, thank you, Mr. Bray. Okay, if there's no other comments, then I shall move on to section 7, part 7 of the agenda. Now, I'm going to contradict myself on this one and say that I do have some comments to make on conditions 17, 28, and 32 of this list. But with regard to those, notwithstanding those 3 conditions, I consider that I have sufficient information on those listed under this item to understand, under those that are marked as no report or comments, to understand each party's position to reach my own conclusion. Do any parties have any matters they wish to raise in relation to those conditions, which haven't been raised previously in submissions? Okay, I'm seeing no hands raised. So I shall move on to condition 17 with regards to access. Excuse me. Stratherick and Foyes Community Council requests explicit clarification on whether the restriction on construction traffic using the B862 to the to the U1140 route applies to the site enabling works. Can the applicant does the applicant have any comment, or can I answer this query?
Yes, sir. The applicant's considered the Community Council's comments on the conditions in respect of the position in respect of the construction traffic on the roads. The applicant doesn't object to clarifying that the restriction on taking construction and operational access across the U1140 Whitebridge to Cullen onto the U1209 equally applies to site enabling works. So insofar as those works would otherwise involve access using those routes. we're content to clarify that within the wording.
Can I ask the Community Council if you have any comment to make in response?
We're happy with that confirmation. Yes, thank you.
Okay, thank you. Okay, moving on to condition 28 now. You have to bear with me as I scroll a bit here. Okay, condition 28 with regards to the outdoor access management plan. Can I ask the applicant's views on the council's proposed rewording of the condition, which was submitted yesterday?
Sorry, can I just clarify? So it's the council's comment regarding seeking the wording or other period edited to part 2.
Yes, yes.
Yes, the applicant accepts that. That's fine.
Okay, moving on to condition 32. Aviation and other lighting. Can I ask the applicant what the response is to the council's points regarding part 2C and the deviation from the standard wording?
All right, I'm just bringing my condition up there, sir. Yeah, so this is in respect of the insertion of commercially reasonable and the council's position that it's not required. The applicant reiterates sort of the position that's been noted previously, that the proposed condition wording is appropriate, that I think any condition that would require implementation irrespective of matters such as cost or proportionality would be unreasonable and go beyond what would reasonably be necessary to mitigate the effects of the development. The applicant's views that the wording as proposed within the condition appropriately secures a future review, and the applicant accepts that, but also that any requirement has to remain technically achievable and lawful and appropriate and proportionate in line with the circular.
The council, have you any comments to make on that?
Yeah, thank you. We've rehearsed this before, I think, with Mr. Trunick on a previous inquiry session for Lochleith Wind Farm, and that is also yet to be determined. However, our comments on commercial viability of introducing this technology is difficult to comprehend why that would be set out in the condition when we have no financial information about the viability of any wind farm development from start to finish. We believe it's unreasonable for that to be inserted.
The applicant, would you like to respond?
Mr. Trunick, have you got anything to add based on recent experience?
There is no recent experience, so I can't really add very much. I'm just intrigued by the wording of the whole of the condition, though, because I have to ask the question. I'm sure there's an answer and I haven't read it through properly, but what happens when the assessment has been made? How is there any power to enforce an ADLS system?
I think, Mr. Trunick, as far as I understand, the proposal for any change would come from the applicant based on the condition, unless the council have got because like under 4, I think it's any proposed amendment to the scheme must be submitted to and receive consent. So my understanding is that condition, it would be the applicant that would propose the revision after carrying out the review, unless any other party has got any concern. So it would be within, or it may be within the applicant's gift.
It would seem to be.
And I think that's why the wording has been has been worded as it is in terms of standard condition, as far as I understand.
Well, sir, my point is that if that is the case, and I believe it to be the case based on what you've said, and I think we have a common understanding of what the condition means, then I guess we don't object to the words commercially reasonable, since the matter is within our gift anyway.
I don't know if the council's got any comment on their understanding of that general condition in terms of the standard conditions.
Yeah, I get your point exactly. It's actually not forcing the applicant to do anything different from what's been installed on site from day one. I think that's a fundamental problem with the condition. There's no point in undertaking a review of what is technically feasible if there is no power sitting within the condition to then act upon that. If the findings are that it's technically feasible, the condition should then go on to require an action to be taken rather than that will be left to the applicant to then progress an alternative scheme for consideration.
Sir, if I may respond to that. You may think I'm speaking against our interest by saying what I've said, and I am addressing the inquiry here, not simply the applicant's position, and try to assist you. If that condition needs amendment, so that a proposal for an ADLS system can be enforced as a result of the assessment, then it makes it a proper condition. But in those circumstances, we would maintain that the words "and commercially reasonable" should be retained. What I suggest is that, here we go again maybe, but whether in closing submissions or otherwise, probably closing submissions, we deal with the points which have just been discussed.
I think the Community Council would like to contribute just now. I see your hand up.
Thank you. I think Mr. Trinick has highlighted very clearly the Community Council's concerned in respect to this condition. This shouldn't be left to the gift. If said that this ideally feasible, and we hope that certainly it has been discussed in relation to other wind farms proposed for this area. It should be the applicant to decide whether they wish to continue with that new issue, and that's why we don't think that it's currently drafted is put sufficient condition on the applicant.
Okay, I don't know if there's any other comments that we can take today. There's it sounds like closing submissions is going to cover all matters concerning this inquiry. I think by the end of this hearing or otherwise, but parties will have the opportunity to do that. And we're aware of what is set out in the standard condition, and we've heard what we have heard today. I don't think we can probably take it further, Mr. Browns.
No, I would agree. So if there is no other further comments on this matter, we can move on to the next item on the agenda, which is those conditions which I've highlighted for discussion. Beginning with condition 10. Apologies. Yes, condition 10 with regards to micrositing. So notwithstanding discussions that we had earlier on around Stromlair, again, legal agreement, which I know there's a bit of overlap here in terms of subject matter. Concerning part 1B, can the applicant advise as to the achievability of this condition within the micrositing allowances? This is a matter that has been raised by the council in their recent comments.
Mr. Bryan, I'm a little bit confused. I thought we were going to discussion with regard to 21, 22, 24, 25, 26.
Did I skip ahead?
But I may not be in tune.
Yes, no. Condition 10 I had originally intended to discuss at the same time as the Strong-Laird legal agreement, but I've moved it in the agenda, following on from the most recent discussions. So we'll start with number 10 and then we're going to move on to number 21.
Okay, right. Thank you for that.
So yes, sorry, I'll just ask that question again. So in light of the council's most recent comments in relation to condition 10 micrositing, concerning part 1B, can the applicant advise as to the achievability of this aspect of the condition within micrositing allowances?
No, I can't. I do not know whether that's achievable. I'd rather wrap this topic up within the general process agreed for Strong-Laird and its concerns. We can address them all together. The answer is I don't know. I'm sorry.
Okay. In terms of wrapping that up with the Strong-Laird matter, does the council have any views on that matter?
No, that's fine. We just highlighted it just in terms of implementation, providing the consent that can be implemented by the applicant. So it was worth checking for them.
Okay. Okay. Nature, Scott?
Only a brief comment, sir. The third comment from the bottom in the final column refers to Nature Scots having made comments in relation to element 1G. I have discussed this with Ms. Tainch, and I understand this is Highlands Council comments rather than a Nature Scot comment. Thank you.
Sorry, yes, just to confirm, yep, Mr. Ferguson and I discussed that yesterday. So, yep, the comment at 1G for seeking peak probing came from the Highland Council officer, not Nature Scot. Just going back to the achievability of micrositing allowances in respect of Part B, yep, I can confirm that, yep, discussing that, but it has, yep, going to be achievable. But as Mr. Trinick said, we'll sort of address the aspects with the Strong-Laird wind farm more widely. Due course, thank you.
So are all parties happy that the further written submissions that were discussed earlier on will take into account micrositing condition B 10 and particularly highlight element B? So we'll include that in what we ask for.
Yes, I can confirm Strong-Laird's happy with that too.
Okay, moving on to condition 21 then, which is the Regional Eagle Conservation Management Plan. It's just a small comment on this one with regards to the reasoning. Can I suggest some reworded reason here, which would be to contribute towards positively affecting the regional conservation status of the golden eagle? Does the applicant have any comments on that suggested rewording?
No, that sounds fine, thank you.
Okay, council?
Council has no difficulty with that.
Okay, and Nature Scot?
It sounds sensible, and I think I can see Ms. Davidson nodding.
Okay, thank you very much. And then we'll move on to condition 22. Construction bird disturbance management plan. Can I ask, is the council's views on the applicant's proposed wording at part 2?
The wording at part 2 has been agreed between the council and the applicant, and the council is satisfied with the condition in its current form.
Right, okay. Thank you. Okay, moving on to condition 24. It is archaeology. Actually, apologies. It's 25 peat and carbon-rich soils. There's a bit of mixed terminology within this condition. It refers to a peat management plan in part 2 and a peat and carbon-rich soils management plan in part 1. Can I ask the applicant to clarify on this point, please?
Yeah, so I think it's just been a reference to the PMP. I think it's just been a crossover from the section 36 model set. So it's a matter of terminology. Happy for consistent terminology to be used throughout.
So it's the peat and carbon-rich soils management plan, the PCRSMP is the preferred. Yep.
So longer acronym, but yeah.
No, that's fine. Part 2 refers to further peat probing work. This strikes me as imprecise wording. Can the applicant advise, is the scope of this work defined anywhere else?
There, if I recall, there's peat probing figures within the EIAR that could possibly be referred to. I'd have to confirm that with the applicant's team to find the best sources to make sure it's the most appropriate one. But happy to review that and add reference.
Yes, I
further
think
reference to
that's
clarify.
exactly. I think we need to reference where that scope is defined. Okay, part 2A refers to the results of further site and ground investigations. Again, this feels to me to be a bit imprecise. Is the scope of this work defined elsewhere?
Sorry, I'm just considering. Again, I believe so. I think it's within one of the technical appendices. I can confirm that. Is it sort of just be by reference to sort of the details that are contained within the current TA? Yep.
Yeah, if those details are in fact there, then yes, I think a reference would be appropriate here. Finally, with regards to part 2B, the wording of this subsection is the meaning of it is a bit unclear to me. Now maybe I'm missing something here, but can you advise of what it is this section is trying to achieve? This is the use of the floating tracks 2B.
I do see what you mean there, sir. I think it is just to define that the floating tracks will be used and form part of the plan. But I do see your point given the wording of how part 2 is referred to in terms of it will be informed by further peat probing work, and so it's just defining the terms of the development, and that there will be the floating tracks will be used following site and ground investigations, as opposed to it being the sort of referred to sort of within the other aspect. And consider if there's a word or something similar that can help sort of better define that. So
Does anybody else have any thoughts on this? Did the council have any thoughts on this matter?
I would just maybe make the point that the use of the floating track should be stated somewhere in the condition and not. I think specifying the extent of the track is useful as well in terms of what's expected and what's been applied for. It doesn't necessarily have to sit within bullet point B. Could be a subsection within the condition that the floating track shall be used, and they should be approximately 2.5 kilometres.
Okay. Anybody else? Any other comments on this matter?
Yes, sir. I have a few brief comments. In relation to element 2G, Nature Scots would suggest that that there is a specific reference to the works being undertaken by a suitably experienced and qualified contractor with experience in handling peat. Dr. Mills, in his evidence, let me see if I have a reference. I think it's paragraph 816 of Dr. Mills' inquiry statement referred to the importance of having a properly experienced contractor on board to handle peat. And therefore, in framing the PMP, we think it should be a component which requires the works to be undertaken by someone suitably experienced.
And sorry, what specific part of part 2 was this you were referring to, or are you suggesting there needs to be an additional part?
It's most obviously relevant to 2I.
2I.
Which already refers to following good practice, but it's perhaps a follow-on to that.
Okay, thank you. And does the applicant have any comments to make on? Oh, sorry, continue.
And under element 3, we would suggest that the management plan be implemented under the supervision of the ecological or environmental, I think it is now, clerk of works. And one final observation, it's more an observation in passing, but in relation to the further ground investigations under 2A, I just wondered in passing whether those are the same ground investigations discussed earlier, pre-commencement ground conditions, or whether it's a further subset of those works, which are specifically in relation to peat.
Okay, Mr. Chunick, I see you've got your hand up.
Yes, I'll address this one. I take Mr. Ferguson's points, but actually I think it's all covered in 25.1, where a plan has to be submitted for approval. Now, that the Highland Council will consult with SEPA and Nature Scott, who can then have their input in terms of the provision of the required expertise in the implementation of the plan and matters under paragraph 2. We don't need to specify that. They'll either approve it or they won't on Nature Scott's, having consulted with Nature Scott and SEPA. So the expertise point can be covered in the formulation of the plan to be approved. In terms of Mr. Ferguson's point about 2A, I don't know is the answer, but I would imagine that's simply geotechnical and geophysical investigations, because that would be all that would be required in order to investigate the minimisation of the loss of peat and carbo-rich soil. Thanks, sir.
Does the council have any views on that?
I would like to suggest that, given the sensitivity of the site and the evidence heard as part of the inquiry process, that it's fully merited based on the applicant's evidence given, that Mr. Ferguson's suggestion about a suitably qualified peat specialist undertaking the work should be included within the condition is bespoke for this site.
Mr. Ferguson, Nature Scott, any further comments?
Yes, I would reiterate the point that that because of the applicant's own evidence, then all that we are suggesting is that there's wording in the condition which highlights something which will be required in the plan. And Mr. Trinick indicated this is something which would be considered in any event. So I think it would be appropriate to signpost that in a condition under element 2. Thank you.
Okay, thank you. I think we've covered that matter now. Mr. Bray, unless you've any other comments or questions? Nope. Okay, I think we shall move on then to the next item, which is number 26, residential amenity. Part 26.1 ends quite abruptly, and in general, the condition reflects only part of the standard wording of the standard condition wording, with alterations in sections that have been kind of dropped out. Can the applicant please advise what their approach was to this condition and why it has been amended in such a way?
Yes, sir, certainly. Noting it has been agreed with Highland Council. This is a case where no background noise measurements were needed because there was no property where it was predicted that noise levels would exceed 35 dB. So in accordance with the old ETSU, not the new Araton, which has replaced it, it was possible to draft a simplified condition, which has been done. Indeed, it's gone beyond a simplified condition by specifying 25 dB rather than the ETSU advised 35 dB. But that's the reason why it's a simplified condition. We don't need to deal with background noise in this case. I hope that answers the point.
Thank you. Do the council have any additional comments to make on that?
Nope.
Okay, thank you. So on to condition 36 now.
That's there is one more point on
Yep, sorry.
26, which was your need to consider the replacement for ETSU, which has come out. The assessment of rating of wind turbine noise, published by DESNES in June 26. And you've had FWS on that, documents 351 and 352, from which you will see that happily the applicant and the council are agreed that no further action is required in terms of the proposed condition in this case, possibly and partly or mainly because no background noise measurements are in play, and we have a simplified condition because of the huge distances to the nearest property. And in terms of amplitude modulation, because that does need to be considered, as you will have seen in the FWS, the applicant and the council agree that condition 26.3, that is to say that the scheme of monitoring can cover that off at that time if it is felt that an AM provision is required. Sorry, amplitude modulation provision is required. But I think that point does need to be covered in your report.
Do you feel that the condition that has been agreed between the applicant and the council needs to be amended in element 3, then, Mr. Trinick, to deal with that? You said a scheme of monitoring would pick that up, but would it be worthwhile amending element 3?
Well, it's got the scheme should include steps to be taken to assess, steps required for background noise. You could add, if you wished, I'm not sure it's necessary, but a reference to amplitude modulation. But I don't think it's necessary, no.
But both parties, yourself and the council, are happy within the context of the new guidance that condition with that suggested change is satisfactory.
Well, yes, we're happy without the suggested change, but I think that the council is also happy, as made clear in its further written submissions.
And I don't know if Mr. Bryans, if you got an answer to your part 1 ends with comma and I think you're wondering, is there something else there, or should that and be there?
Yes, I was going to ask that question also. So part 1 of the proposed condition here just seems to kind of end mid-sentence. I'm wondering what has went awry here, essentially, and is there a piece of your intended condition missing, or is it just an error?
Sorry, I'm just going to double check it to the earlier set of proposed conditions and just see if it's just an issue that's been, that was originally in the draft. condition is at 26, or if it's just been when everything's been transferred over to the new template. I believe it is just a typo, but I'll just double check while we're there.
So do you mean the comma and the and? In other words, you would expect to see a full stop after consent?
Well, I expect to not see a sentence end with and. I think is what you intended to be in there is the question.
I think the condition makes perfect sense if you put a full stop after consent and delete the comma and.
Was that the intention, Ms. Stanish?
Yes, it is. Yeah, it was in the original set as well, so I think it's just been a typo. So happy for that to be removed, as Mr. Trinick suggests.
Okay, is there any other comments on this condition? Okay, we will move on to condition 36 then. So this is condition 36, financial guarantee. Can I ask the applicant to please advise with regards to the space holders in this? Basically, it would be my suggestion that condition 34 and 35 are the appropriate conditions that go into the space holders here, but I would like your confirmation or your views on that.
Yes, yeah, sorry, it would be. Yeah, for the space holders, yeah. Yes, for 1 and 2. Yeah. Happy with that. I think it was just when it was, being prepared and then conditions get added and changed along the way. But yes, happy with that.
Absolutely. Anybody else? Any other views on that? Okay, thank you very much. Okay, at this point, can I ask, do any parties have any other matters that they wish to raise with regards to the conditions in part 7 of the agenda before we move on to item number 8? Okay, I'm not seeing any hands raised. Okay, we'll move on to item number 8, which are the deemed planning conditions. So at this stage, contrary to the agenda, I do have some questions relating to each of the conditions in this section. So what we'll do is I'll just run through them as we've previously done. Condition 10, no, we're not condition 10, sorry. Condition 12, construction and environmental management plan is the one we will begin with. Okay, sorry, hang on.
I think I've got one query on that condition. If you want me to go first, is that item K, which is construction breeding bird protection plan. The question is that necessary in the context of a specific a condition dealing with that? Is there a need for item K when we have condition number 22? Maybe they're different things. One is a construction bird disturbance management plan, and the other one's a construction breeding bird protection plan. But it was just to get clarity whether or not they are one and the same thing, or if they are indeed separate. I don't know if the applicant wants to go first.
Yes, sorry, just confirming there, sir. So yes, there would be, it would be akin to what we already have within condition 22, the construction bird disturbance management plan. So agree for the removal of that to avoid any confusion.
And does the council agree with that?
I agree, it's the same thing. It's a cross-reference essentially for the appointed contractor to check in preparation of their CENP that they're taking cognizance of that plan.
Okay, is any other parties, any other issues to raise on that matter? Okay, we shall move on to condition 15, which is construction hours. Noting the content of the Highland Council's response regarding construction and ATGV movement hours and the comments of the Community Council, can the applicant please comment as to why the council's suggested amendments have not been incorporated?
Yep, so reviewing the council's revised position from the 18th, it was submitted yesterday. Yep, the applicants considered that, and yep, we'd find it would be willing to accept revised wording in respect of until 1 p.m. on Saturdays for HGV movements. I'm happy for the condition to be amended to reflect that in part 2.
Did the council have any further comments on that matter?
Just an observation, the current draft wording actually specifies a 7 a.m. start time, and that is no longer in keeping with modern conditions issued by the Highland Council. We usually specify an 8 p.m. start time. It's particularly relevant for this application site because the HGV traffic will be traversing through communities on the road network. If you specify a 7 a.m. start time, that construction traffic will be taking place obviously in advance of 7 a.m. in the morning. We therefore think it's reasonable in this location that an 8 a.m. start time in the morning is more favourable in terms of protecting residential amenity.
The applicant's response to that?
So the applicant has assessed based on 7 a.m. and thinks it's reasonable in what has been assessed. But if yourselves consider it appropriate for 8 in the morning, then yeah, the applicant would be willing to accept that. But otherwise, still maintains that 7 a.m. would be preferred.
Community Council, have you any comments to make on this matter?
Yes, we would support a view that an 8 a.m. start is more appropriate. It's a 40 minutes drive from the A9 all the way down the B1 and B862 to the site entrance, and that's the applicant has indicated construction traffic. That means it will be passing residential property. If construction starts at 7 a.m., that means it's passing residential properties from soon after the 6 running, which is too early in our view. We'd also highlight in our submission that we're unclear as to, well, we're clear that we need a condition that covers HGV traffic coming along the B85162 during school pick up and drop off time, but we're unclear whether that's better covered in this particular condition or under traffic. As long as it's secured by condition in one or other area, we will be consent. We'll leave it up to you whether you want to sit here or later.
Does the applicant wish to make any response to those points?
Can I just seek clarification from Mr. Hindley of you half caught what you said about school hours? Which school are we talking about?
So for children from Whitebridge attend high school at Edinburgh IRA, Inverness Royal Academy. The school bus leaves Knocky Road End at 35 in the morning and then drive a rather circuitous route to IRA along the South Loch Ness B Road network. collecting children who are just waiting at the road for the bus to come. There are no bus stops, just waiting at the end of their drive or where the road meets. They would be particularly vulnerable to HGV traffic passing them whilst they're waiting for the bus.
Thank you. Lizzie Tainch will deal with this point.
Yeah, so the applicants considered the Community Council's position in respect of that. And our view is that based on condition 16, so the construction traffic management plan being provided as a plan that will be sort of implemented as approved by the council, that provides an appropriate mechanism for sort of the final details in terms of school hours and things which could be accommodated within the plan. So, for example, with when accommodating drop-off and pick-ups times and sort of periods out with school holidays. That could form part of the finer detail that would be approved by the council prior to the works commencing.
Thank you. Any comments on that from any other parties before we move on? Okay, moving on to condition 16 and traffic management. Can the applicant please provide us an update of where we are with regards to discussions relating to financial contributions and their view on the council's recent comments, and in particular the proposed revision to Part 1R?
Yes, sir, certainly. You've already had extensive further written submissions on this topic, documents 327 to 333. And I'm not going to repeat the submissions made, but I'm going to summarise the position as follows. For the Dell 1 site, blades were to come from the Cara Localsh via Fort Augustus, and from there up the B862 over the Sui Pass to the site entrance. Towers were to come from Kopak to Fort Augustus and then up the B862. So all major components would come from the south, and with only a proportion, I don't know what proportion, of HGV and staff traffic coming from the north. For Dell 2, all AIL movements will come from Inverness via the A9, the B851 and the B852. Only a proportion, again, don't know what, of the HGV and staff traffic will come from the south. Now that is a vast difference between Dell 1 and Dell 2, which the council has simply failed to acknowledge in its further written submissions. The access is coming from the north, not the south. Now the offer of a contribution of 1.7 million to road improvements and mitigation measures for Dell 1 reflected AIL traffic coming from the south. The offer was made in that specific context and was secured in principle, although no sum was recorded, and condition 11 imposed on the Dell 1 consent, document 799, which you can read for yourselves. But I do ask you when you read it to note that while Part G provided for the financial contribution, we also have Part H, which is a requirement for a Section 96 Roads Act 1984 agreement to cover wear and tear as a result of extraordinary traffic, i.e. traffic generated by the development. So coming back to Dell 1, Dell 2, comparisons with Dell 1 are wholly irrelevant, even if Highland Council were to claim some mitigation or even improvement based on non-AIL traffic coming to Dell 2 from the south. The calculation of 1.7 million was made on the basis of the intended access route. For Dell 2, there's been no calculation of what sum for mitigation or even improvement might be appropriate. The offer of 450,000, which represents no more than a goodwill offer in an attempt to avoid a confrontation. No more than that. And the applicant has maintained that offer and does so today, even though there can be no good reason based on Circular 4 of 1998 for a condition of securing a payment. After all, if we look at condition 16S in the draft agreement, that, as with Dell 1, proposes a Section 96 Roads Act agreement requiring the cost of any damage to the road directly due to the development to be met by the developer. Finally, I referred to the decision on the Corrigarth 2 wind farm, document 791. If you look at paragraphs on electronic page 14, I don't think you need to go there, do if you wish. Paragraph 77 to 80. We had exactly the same tussle on that project, and the reporter said that no contribution was required, in terms which I wholly endorse.
The routing was proposed from the south on the B862 to come in off the A82 at Fort Augustus and route northwards to the site. And on the basis of the condition and the physical limitations of the B862 over that length, we agreed with the applicant on the contribution, and that was going to be directed to the Loch Tarf to Suey Viewpoint scheme of our South Loch Ness Road Improvement Strategy. And there is a vast difference between routing from the south to the site as opposed to routing from the north from the A9, in that the length of the route that is below the minimum width standard for a B-class road is significantly greater. It falls below that, and to a much greater degree from the north. There's a greater length of public road being utilised, of which a higher percentage of it is below the minimum width standard for that route, and therefore the impacts are actually greater if you route from the north south down to the site than it would be if you were routing from the north. So I agree with some of the context that Mr. Trinick explained, but not his conclusion, because his conclusion suggests that the route from the north is in a much better condition and physical width form over its length, which it is clearly not. So just to clarify, the strategy has split into discrete schemes that are on the predominant route that has been used to date, which is the B851 and the B862 between the A9 and the A82. And we have something in the order of 50 discrete schemes there, and we're going from the north to the south. The Suey Viewpoint down to Loch Tarf is scheme 47. So we have a significant number of schemes above that, and we've got a significant length that is below the minimum standard for its route class being a B-class road.
Just to elaborate, Colin, on quantum that's being asked by the council. So the previously agreed amount of 1.7, obviously subject to indexation. Time has now moved on. The Roads Authority and the council are not asking for any different amount. Essentially what we're doing is looking at the HGV traffic associated with this proposal Dell 2 now, and proportionately uplifting the original figure. That's what's being proposed.
That's right. I think we've got that 1.7 figure from the Dell 1 consent that was endorsed for good reason. And what we're saying is that if there's an increase of traffic, we have a pro rata increase to that value, and then we index link it from, I think it was 2019, I think, maybe stand corrected, but from that date to the date at which either the works would be carried out or the financial contribution would be provided.
And in terms of Mr. Trinick's reference to Corrigarth 2 wind farm and one reporter's conclusion in terms of that proposal,
that's right.
There are obviously other reporters' decisions on this road.
So the Red John stroke Loch Cartrick, where they endorsed the South Loch Ness Road Improvement Strategy and the need to carry out road mitigation to bring that road up to better accommodate the adverse impacts of the transport that was going to be generated by the development.
Okay, thank you. Before I return to the applicant, Mr. Hindley, I believe you have some comments you would like to make.
Yes, I was going to make all of the comments that Mr. Ross and Mr. Whelan have made, and the Community Council fully supports those. Mr. Absolutely correct that the proposed route for Dell 2 is entirely different from Dell 1, but his conclusion that he draws from is completely incorrect. The road access from the north is far worse than that at Fort Augustus. So the impact of the South Loch Ness B Road network of Dell are far greater than those that were as would have occurred as a result of Dell 1. And the applicants' financial contributions towards the South Loch Ness Road improvement and the required mitigation actually should be greater than those that were agreed as part of Dell 1.
Okay, Mr. Trinick, would you like to come back on that?
Yes, I would. As I understand it, what the council appear to have done is to say, well, we had 1.7 million secure for Dell 1. Yeah, it's a completely different access, but tell you what, we'll just transfer that sum to a completely different access and increase it pro rata with a bit of index linking. Where's the calculation of the works which are actually required? This is a figure plucked out of the air. There's no foundation for it at all. We've seen no evidence to support the 1.8, 1.7 million whatsoever. There's no calculation that this improvement is required or this mitigation is required. It's a figure out of the air. So the answer is no. Secondly, Red John, I don't know, it's not before the inquiry. So I ask you to reject that reference totally. That Red John decision is not before the inquiry. You can't look at it. Thirdly, mitigation, yes, of course. Section 96 of the Roads Act provides that extraordinary traffic wear and tear damage must be met by the developer, and we're perfectly happy to do that. But road improvements? No. That goes beyond what any developer should be required to do. If people volunteer to do it and consents are issued without an inquiry, well, fine, they must do what they want. But this is an inquiry, and the point is being tested, and we wholly reject the condition. Thank you.
Okay, thank you very much. I think we've probably covered this topic matter enough, unless there's any burning issues that anybody else wants to raise.
Yeah, I was just going to.
Council?
I was just going to raise in advance of anyone else. The condition, as currently worded, the requirement of the condition is to submit a construction a management plan, and that's to be approved. And within that, the construction traffic management plan shall provide a certain number of things. One of which is as currently worded, includes reference to two roads agreements, and that is that the transport management plans should have reference to those. What the council seems to be suggesting is a separate condition. The way it's worded is that there shall be no commencement of development until. That wouldn't fit in with the current wording of the condition, which sets out a range of parameters, if you like, for the traffic management plan. So I'd be quite keen to understand if the council is looking for a standalone, separate condition, as is worded, because it doesn't fit within the kind of setup, if you like, of that a condition as it's currently worded. So if I could get the council's view on that, are you requiring or asking for the reporters to consider a separate condition that is out with the management plan to the council?
I don't think that's necessary, to be honest. I think what we can do under section R, as it currently is drafted, is essentially delete the first 3 lines where that subsection would start an agreement. So the CTMP must include an agreement, and that would resolve having a separate planning condition on this.
Okay, that's helpful from that point of view. My second point is generally the kind of general relevance of covering roads agreement in planning decisions and requiring those where they're covered by other regulations. I would be interested in the applicant's views on whether or not planning conditions should be getting into the territory of the specificity of the content of such a roads agreement, given that they are a set of separate sort of regulations. At the moment, the condition just essentially requires the agreements to be in place. That's as far as it goes with reference to the transport management plan. But I would be interested in the applicant's view on getting into the detail of any such agreements within planning conditions. Sorry, that was a bit long-winded, Mr. Trinick.
That's all right, sir. I'll start with section 96. No, we sometimes agree to the insertion of wording in a condition, but technically I think it should not be in the condition, because section 96 of the Roads Act provides that damage due to extraordinary traffic, which we acknowledge wind farm construction traffic is, shall be remedied at the cost of the developer. So a separate legal provision, meaning you don't need a condition. So far as part R is concerned, well, I don't think there's no separate law requiring this sort of thing. So if it's going to be secured, it's going to have to be secured by condition. I think it would be a separate condition, not just part of the construction traffic management plan condition. It's a lot simpler if you agree there should be such a provision to separate it out and put it in its own condition. But you've heard my views. I think it's utterly inappropriate and is not required. I also note that at the end of part R, there's a reference to an agreement dated something or other. No idea what that means. There is no agreement.
And perhaps back to the council with regard to the Mr. Trinick's comment about the decision. I don't know if it's a decision or a report or deliberations on a scheme that you mentioned, Red John. Is that a ministerial decision, and do we have it in front of us? I don't think we have. I think Mr. Trinick's view is that we don't have it in front of us, but is that a decision?
Yeah, the reason for referencing it was Mr. Trinick referenced a reporter's decision, or sorry, the Scottish Government Minister's decision on the Corrigarth 2, where they rejected the need for road mitigation. And the point I was making was that the Loch na Catterick, or Red John as it was originally called, that was also a Scottish Government decision where they did endorse the South Loch Ness Road Improvement Strategy. They did endorse the need for road mitigation. So in referencing Corrigarth 2, because it suits his position, he's ignoring the fact that on our position, the Scottish Government reporter and the ministers agreed that road mitigation for the B862 and the B851 was required. So that's why I referenced that. And yes, it's not, that decision is not under sort of discussion in itself, and neither is the Corrigarth 2. They're just referencing decisions that went both ways, if you like.
So do we have the Corrigarth 2 decision? Excuse my lack of knowledge of the detail of our documents list, but perhaps someone can double check that whether we have it or not.
Yes, sir, you do. I'll give you the document number.
Yep.
It's 791. That's the reporter's inquiry report. But the decision is also there, from which you see that the ministers accepted the reporter's relevant views on road improvements. So that is before the inquiry. What we don't know about Red John, and we can't know because the document's not before the inquiry, is whether or not the applicants resisted the mitigation, I've heard the word, mitigation payment, or volunteered it. I don't know. We don't know enough to make any comment about that.
I think it'd be difficult to have a discussion on that today without seeing the document. Do any parties have any objection to the Scottish Minister's decision being submitted? Not necessarily any other commentary, but just simply that decision, since it's been mentioned today, and we have allowed other documentation. Mr. Trinick.
No, sir. We actually welcome that document coming in for reasons I will give when we have the document in front of us.
Thank you, Mr. Trinick. All parties will be able to obviously comment on matters and closing submissions, but does the council have any problem with that?
No, that's fine. We can issue the document immediately after the hearing session. That's fine.
Yeah, that's fine. Just for the moment, as long as there's no comment on it, we're just looking for the document. So if we just make that clear for the moment. Sorry, Mr. Banks.
Sorry.
Yeah, no. Carry on.
I just wanted to give a bit of clarification on a couple of points that Mr. Trinick raised a short time ago. Correct me if I'm wrong, but I think he suggested there was no kind of basis for the 1.7 million. That's not correct. The 1.7 million was in reference to providing Scheme 47, which was Lochtarf to the Suey viewpoint in the Dell 1, the original application. That was how we were going to upgrade that section to accommodate and the traffic from Dell 1. We looked at that, and in discussion with Coriolis, who were the agent for the applicant, we arrived at a value of that work being 1.7 million. We also had asked for a £200,000 contingency for Scheme 46A, which was a road safety improvement scheme at the Suey viewpoint because of the road geometry, the poor visibility, and the potential for conflicts with locals and tourists stopping there. It's actually not a particularly great safety area. The £200,000 contingency for that was not taken through, but the 1.7 was. So the 1.7 has got basis, and the applicant and their agent had agreed with that in the lead up to the Dell 1 decision. So Mr. Trinick's comments of saying it's got no basis is incorrect. And on the Section 96, I think construction traffic management plans and Section 96 agreements are really, they've got a basis, they're really useful and they're effective, but they can only do so much. So what you have is a Section 96 is where there has been deterioration and damage. All that's really required is that you bring the road back to the condition it was in prior to your traffic causing that damage. So if we already have a poor standard road, all the applicant is required to do through a Section 96 is to bring it back to that poor standard. It's been deteriorated to a worse standard, and you bring it back. So it's a secondary and complementary sort of measure in mitigation. What it doesn't do is address the physical form of the road, where opposing cars and vehicles are having to leave the surface carriageway to navigate down the road for opposing traffic, because the road is simply not wide enough in significant length. So a casual inspection of the B851 and the B862 highlights the needs, and anyone that has driven that road will understand where we have already improved the road through developer road mitigation and through capital investment by the council. These issues are not there. That sections, there's no issue with them. Safety is better, the road integrity is better. Where we've improved within the villages and the settlements, that is better. The impacts on the residents and kids going to the school, going to the local amenity facilities are much better addressed, and we're not looking to further enhance them. So if your road was of a good standard and of a consistent width all the way down that was suitable for the traffic, you would still require a section 96. Section 96 would be something you would still require, or we could retrospectively use it through the powers of the Road Scotland Act. So it doesn't demonstrate a need that how the road is already, if it is ready and capable, safely and suitably to cater for that traffic. It's a retrospective means of addressing damage. And that's the only element of mitigation. If your road is not fit to cater for that traffic in the first place, that's why mitigation is needed. And that mitigation should be the physical upgrades to bring it to the minimum standard that's needed for the base traffic plus development traffic. And that's what the strategy seeks to do. Just thought it was useful to clarify that. Thanks.
Thanks for that. But perhaps a question for your colleagues within it is it the Town Council's practice to impose planning conditions requiring a Section 48 agreement that specifies certain works with large scale developments? Do you consider that to be a sort of competent planning condition that you impose regularly on larger scale developments, the agreement of a Section 48 roads agreement? Maybe to Mr. Whelan.
I would suggest that the reference to the Section 48 legal agreement is a relatively new addition. Previous conditions that I've seen in the past, it will make reference to a scheme of road mitigation improvements to be undertaken, rather than specifying an agreement. Now, in fairness, that doesn't leave you with much precision if you're, for example, taking on a wind farm development and going to make it abundantly clear in the conditions that are drafted, if this is the way of a decision to be issued, that a scheme of road mitigation works will be required and a Section 48 roads agreement requires to be concluded as well. I appreciate Mr. Trinick's view and that planning conditions shouldn't duplicate what other provisions there are under different acts. I fully understand that. But if you were to implement this scheme and you were not involved in this discussion, due diligence would indicate for transparency that it's better to put it in the condition.
Thank you for that. Thank you for that. Mr. Trinick, I think you've raised your hand.
Yes, thank you, sir. All we've heard from Mr. Ross is how an agreement was reached for Dell 1. That's all he said. And we've had nothing to explain why the council simply wishes to transfer the agreed sum from a completely different access onto Dell 2. There are no calculations to support the request from Highland Council. I've already said that, but his own additions confirm that. So far as Section 96 is concerned, it can only do so much. It does what is required. We're not obliged to do more than to restore the road to the condition it was in prior to the development. We're not required to improve roads. And if you look at condition 16B, that actually provides for temporary and permanent works to the local roads that will be required to physically and safely accommodate abnormal load movements to and from the development. So we have to provide those measures anyway. So I'm sorry, nothing that's been said persuades me to mitigate the position I put forward. Thank you.
Just quickly to clarify on that, it's not that it's a completely different route. It's the same route. You know, the B862, you're just north of the site. It's the same route, and what we have, and we did explain earlier, which maybe have been missed, is that there is a greater length of that road of the B862 and then on the B851, which they would be using, which is below the minimum standard for its route class. And what we have of the route coming down from the A9 that Dell 2 would utilise of the B851, 42% of that route is below the minimum width standard for a B-class road. And on the B862, 59% of that road is below the minimum width standard. Now, if you're below the minimum width standard, sorry for having to explain this because I think it would be pretty obvious. If you're not got a sufficiently wide road to accommodate two-way traffic, you are going to encounter conflicts with vehicles. That presents a road safety issue for the applicant's construction traffic, and it also presents a road safety issue for other road users and for the residents that live on that road in the communities. And you also have a continual breakdown of the fabric of the road if you have to leave the surface carriageway. So when you drive these routes, you have extensive edge overrun where vehicles, not your HGVs, but just even cars, are having to drive on the soft verge. So they're off the surface carriageway. These are evolved roads. They're not designed, evolved routes. They're not designed roads. And what we're trying to do is bring them up to a standard that is capable and suitable to cater for the transport demands that are being placed on it. And it's that you're mitigating. And a Section 96, you're right, it can only do what it's set out to do. But that doesn't mitigate the transport impacts. It only deals with just damage. What we've got is we've got a reduction of road safety standards along that route because of additional traffic, and we have a continual erosion and a reduction in the integrity of the road just through mechanisms of the breakdown of the fabric of the road because of this additional traffic. And if you can look at the condition and the safety standards in the sections of the B851 and the B862 that we have brought up to that minimum standard that we have set out in the strategy, it caters for the traffic really well. Safety standards are much higher. Your drivability of that road is improved, and everything. We're not seeking anything on those sections because they are capable of catering for base plus development traffic, and that's basically it. So, and I think if people drive the route, the disparity between the sections we're looking to upgrade and the ones we have already, it's so obvious.
Okay. I think we've probably, I don't know if Mr. Brown's got any other questions, but we've probably heard what the parties feel about that, and we can look through all the evidence that the councillors have submitted on these matters and the comments that we've had by the applicant. But Mr. Trinick, you do have your hand up.
Only to make a point, we're going in circles, so nothing more to add, except that if you look at document, I don't know what it is, but if you look at the objection by Highland Council to the proposed development, it's in three parts: landscape and visual, peatland and flood risk. There is no objection based on access, no objection based on transport. Thank you.
Thank you, Mr. Trinick. Mr. Hindley.
Sorry to prolong this. Look at Stratherick and Foyers Community Councils. Again, to this, you'll find that we did object this of the current condition of the road and incapable of accommodating the proposed.
Thank you. Sorry, Mr. Brown, I've been talking a little bit too much, perhaps.
No, thank you very much, Mr. Bright. No, I am content to move on to the next condition, unless there's any objections to that. No, okay. So we'll move on to condition 18, which is refers to access liaison. Now, I know that the Community Council have raised some points with regards to this condition, in particular, with a point concerning that the liaison process should be a two-way process. seems to be of particular importance. Can I ask the applicant if they have reviewed this point and what their comments are on that?
Yes, sir. So, yeah, the applicant sort of understands the community council's position on it. However, our view is that the condition already drafted provides for the access liaison plan to be submitted and approved by the council. So there already is the council's role within prior to implementation, and they will retain control over the content of the plan and the measures to be implemented prior to commencement of development. And that should be sufficient to address all the related measures that will go within the plan.
So sorry, just to be clear, you would expect the kind of two-way process that the community council are talking about here, and in terms of, you know, not just be a reporting role by the applicant themselves, but you know, a give and a take. You would expect that to be specified within the document itself before agreed. Is that correct?
So, I may defer to the applicant for that one, but it's my understanding that there will be feedback as part of that role. I'll let Richard sort of pick up on that a bit more.
It would just be fulfilling the same role as the access liaison does already.
Does the council have any views on this?
No, the council doesn't have any comments to make. Thank you.
Okay, Mr. Hindley.
Yes, I'm not quite understood the applicant's response then. Certainly in condition 18 as drafted, one says the liaison group acts for the community to be kept informed of the project process by the company. And our assertion is this should be a two-way process, that it should also be a vehicle for community to be able to liaise effectively with the applicant. It's not just a one-way process. And the other item that the community feels very strongly about is that given the current load of large energy projects in our region, in the Stratherick and Foyers Community Council area, we have one wind farm currently, we have one about to start construction, we have more which have planning consented, we have one pump storage consented, we have one pump storage scheme that is just finishing, and we have one pump storage scheme that's just about to end planning. We have a population of 800 people, and to have separate liaison groups for all of the projects is simply not feasible. This was discussed at a meeting with Kate, convened by Kate Forbes, when our constituency MP, agreed at that meeting that we should have a single liaison group that different projects and left as their projects periods came on stream, because it is a more sustainable way of to actually try and liaise with multiple large-scale energy schemes. It's not feasible for us to populate 4 or 5 or 6 concurrent liaison groups.
Mr. Trinick, I see you have your hand up.
Yeah, I do have sympathy with what Mr. Hindley says in terms of community resource. So if there is an existing liaison group that we could join, that's fine, provided that we don't have cross-contamination between projects in terms of expectations, that the project is looked at as a single project by that group. That's fine. In terms of the wording of the condition, I can also see why he says that what it appears to say is it's a vehicle for the community to be kept informed rather than two-way process. Obviously, the plan has to be approved, and the plan won't be approved unless it's acceptable to the council, who will have this very point in mind. So the required two-way liaison provisions could be included. But if you saw fit, that condition could be amended so as to specifically provide for a two-way process with some wording. I'm not going to try and draft on the hoof, but that could be done. So I have some sympathy with Mr. Hindley's point of view.
Can I ask the council what their view on this would be? Would it be preferable to address this through the purification of the condition and approving the plan, or would you prefer it to be specifically addressed within an amended condition?
I think it would be preferable to have it as an amended condition. Given the time it may take between this session and when development takes place, it could be long forgotten what the community's wishes were at this point in time. So it would be beneficial if that was redrafted to include two-way liaison. If there is scope to amalgamate CLGs for multiple projects, the condition wording could suggest, with a view of seeking to coordinate meetings with other major developments within affected community council areas. Now, I think it would be unrealistic to force them to all hold the meetings on the same evening. Some of these sessions may well merit separate meeting dates for the initiation of such sites. They're also affecting different users within the community. Some may be interested in certain routes and others may not. So it's a great suggestion, but in practice, we need to see how that would work.
Okay, thank you very much. And in terms of how we capture these changes, or to the applicant, are we suggesting that these are addressed through the closing subs?
Yes.
Okay, is there any other comments on this condition?
Had the council, based on the table, suggested an alternative, longer, more specific wording, or is that still the council's view? I think that's the council commentary of the 28th of April, 24. Or are you happy with the discussion that we've had, that the proposed amendment to the existing condition would satisfy the council?
I think our preference still remains as set out in the written submission. This particular area is subject to local events. ETAP, for example, goes around Loch Ness. There is heavily influenced by the tourist season as well. There's relevant points within the previously worded Dell condition that, should the reporter wish to review that, could be inserted into the revised condition. It's a point we can cover again in the closing submission if necessary.
Yeah. Thanks for that.
Okay, thank you. In that case, we will move on to condition number 19 of normal loads. So noting the council's submission yesterday with regards to part 1G and part 7, can I ask for the council's comments on this matter?
Sorry, so which condition are we on?
Sorry, we're on condition 19, and part 1 and part G speak to cross purposes essentially, and the council have pointed this out, and I'm wondering what the applicant's comments on this are.
Apologies, sir. I thought it was the council's comments you were asking for in the first instance.
I might have made a mistake.
Sorry.
Sorry.
No, it's fine. It's absolutely fine. Yep, so the applicants considered the council's position set out on the 18th. Notice it, appreciating the views. The applicant's view remains that the ELRA will identify the physical works that are required along the route and that would be sufficient for the purposes of the condition to address that aspect.
Of the council, any points to raise in response to this?
Yeah, this is a recurring issue that's happening as turbine components are getting larger across the region. We are seeing more trees being removed along our roadsides, and if the consent is granted for wind farm development and it has an abnormal load assessment undertaken, what that abnormal load assessment doesn't include is an agricultural assessment of the trees to be lost, their quality, and any compensation for those losses either. I think the applicant stating is that from their review of the ALRA, that no trees are to be removed, if that's my understanding. However, we have not corroborated that by checking every turn and every footpath to confirm that that's the case. Believe that detail should be left and appropriated to condition stage, to ensure that in the event that further tree removal is required, there is a chance to consult with the forestry officer for agricultural assessment to be undertaken and to confirm the extent of those losses. Or indeed, if there's an alternative scenario to avoid tree losses in the first instance, to maintain the character of the landscape and visual amenity in the area. So this is a condition that we're looking to impose upon all wind farm consents moving forward in the region for that reason.
Okay, thank you. Does the applicant wish to make a response to that?
Yeah, no, the applicant understands the council's overall view for projects moving forward. As I do understand it, I believe there aren't any tree losses along the route. It is just trimming. However, we consider that the condition is appropriate as it's presently worded.
Okay, unless there's any other issues anybody would like to raise, we can move on. Is there any other comments? Okay, thank you. We'll move on to condition number 20, which is habitats and ecology. Can I ask, again, in light of the comments that were made by the council yesterday, can I ask the applicant if they've any response, any points they want to raise in response to this?
So just working through the council's position in respect of part A, the original part A. This does appear to have been an error when transferring the conditions across from the original 10.5 set to the new template. So accept that amendment, which aligns with the comment above from the 25th of May from the applicant. So the wording included here set out by the council is accepted by the applicant. In respect of point B, which the council now puts forward, this was sort of new wording to consider from sort of my review last night and discussing it with the applicant. It does appear to generally align with the OHRMP and sort of cobbling together the different areas and things like that. It does look like that's addressed. However, I think in order to sort of not have required that level of sort of detail to be set out fully within the plan, sort of revert back to a position of noted a few times, whereas the plan already requires sort of the submission of the finalised BEMP, which would detail the mechanisms which we put in place, and then would be approved by the council prior to commencement of development. So that should be sufficient. However, if it would benefit the reporters, it can look at the finer detail proposed by the council following the hearing. Otherwise, maintain our view that that's sufficient as a plan overall.
Thank you. Can I ask the council's view on that matter, that the specific details within the suggested rewording would be covered by the BEMP and consented via that process?
Yeah, firstly, I will apologise for not proposing this wording from the outset because I think it is quite critical that it is included. If not in its full form as set out in the council's wording as suggested, but to have no reference at all to any minimum amount of peatland restoration to be undertaken would seem not to align with other recent consents that I've seen, where a specified minimum amount of restoration is set out. The applicants have committed to the amounts quoted in the response that's been highlighted and circulated. It is a substantial area, obviously 231 hectares, for example, and I think leaving it to standard wording to say that we'll agree this in due course does not give any recourse if that amount did not materialise at a later date.
I wonder if the applicant is able to confirm the figures in the proposed MOU. We can obviously double check them. Is it the overall hectareage that you have a concern with, or is it the kind of sub-level detail with regard to the smaller areas that you've got a concern with being put into the condition? Or do you have a concern with any of the figures?
No, I think Mr. Whelan's right that we should provide for a minimum hectareage of peatland restoration, because that was provided for in the Cloyk consent. It was provided for, it's been provided for elsewhere anyway, and you've got the evidence on that from the inquiry session, so I needn't go into that. My only concern is that actually, I think the 8 hectares, presumably, was 8 kilometres, I don't know what it is, of gully blocking falls within the 231. It's not additional to. And the 57 hectares of Montane Heath, I need to check all these figures and want to make sure we're not adding them rather than expressing them as part of the 231 hectares. So I think that needs checking. In principle, I don't think we could object to the A figure going in, because that's what we've committed to in the evidence.
Thank you, Mr. Tennant.
Okay, before we move on, is there any other points anyone would like to raise? Mr. Ferguson?
Yes, sir. It's a similar point to condition 25, where there should be a specific reference to the peatland aspects of this plan being delivered by a suitably qualified peatland contractor.
Does the applicant wish to make a comment on that?
Yes, sir, the same one I made about condition 25. That the plan, if the plan is going to be approved, it will be consulted upon with Nature Scott, and they can make their point then, and the provision of expertise can be built into the approved plan. We don't need to specify every detail at this stage. The only other point to make was, do you propose a process for checking those figures within the condition? Do you want to deal with that in closing submissions or otherwise?
I think at the end of this conditions hearing today, we'll discuss that, because there's perhaps more than we anticipated it to be left. So we'll ponder that and come back to you at the end of the session, just how we're going to deal with it.
Thanks, sir.
Okay, thank you very much. If there isn't any additional points to be raised, we'll move on to the next condition to be discussed, which is condition 29. Which is private water supplies. Can I ask, with regards to part 1 in this condition, is the applicant proposing that the words "at the date of this planning permission" are included or excluded? It wasn't clear for me between the amendments that were made with the word structure and then a commentary. Can you provide a bit of clarification on that, please?
Yes, sir. So the wording at the date of this planning permission in part 1 was sought by the Highland Council officer. However, it's the applicant's position is that that wording is removed. It's not reasonable to require the applicant to address all developments that may come forward in the future within the condition.
Can I ask the Highland Council what their comments are on this matter, please?
Thank you, sir. This condition is now agreed and satisfactory to the council.
Okay. Part 2E, details of mitigation, again strikes me as a bit imprecise in terms of its wording. Can the applicant extrapolate this or explain to me what exactly that's looking to address and how we could potentially capture a bit more precision in that part?
Yes, sir. I can't remember off the top of my head where the scoring out came from, the council or the applicant. However, I do see your point that some additional wording may be beneficial. There'll be the mitigation in terms of the private water supply plan. But yes, happy to review the wording and add some additional clarification surrounding that for the mitigation in terms of the private water supplies, if that would assist.
I think it definitely. I think in its current format, it's definitely not clear what is meant by that. I don't know if the council, if you have a stronger memory of the discussions around this and what was looking to be achieved.
Unfortunately not. All I can say is that the monitoring scheme that's been scored out for water quality is again covered by part F below, I think. I can recall, to be honest, when we need to consult with environmental health to confirm if they're content with the wording or not.
Okay, thank you. I think.
So one more point on this condition. If it's been covered, I apologise, but you referred to the scored out wording in part 1, date of permission. However that happened, I don't know, but I think the words need to be restored. We can't be held hostage to future development taking place which utilise private water supplies.
So we're proposing that the scored out words are included.
Yes.
Yes, Highland Council, I see nodding. So you're in agreement with that?
Yeah.
Okay.
And would that be the date of consent or the date of the planning permission, given it's a deemed consent, or is there no strong preferences for that, Mr. Trinity?
No strong preferences at all.
That's fine. I think it'll be clear, probably, with the current wording.
Okay, any other comments to be made on this condition? Nope. Okay, let's move on to condition 37 then, please, which is ear management. The proposed word in this condition again includes some space holders for the appropriate documents list and the appropriate reference. To me, it seems to be the reference 007.008 and the date June 26th. Can the applicant please confirm this, if this is correct?
Yes, that is correct.
Okay. Also, we're lacking a proposed reason for this proposed condition. I don't know if the applicant has just has this and has forgotten to attach it, but I would seek their vision on that.
You're right. I could try and draft one on the hoof, but I'd rather submit it to you in writing.
Okay, thank you very much. And in
Mr.
terms of
Ferguson, I think,
council,
has put his hand up.
didn't see that. Yes, Mr. Ferguson.
Yes, sir. It's a request that Nature Scots be consulted on the final version of the plan by the approval of the plan is for the council, but Nature Scot would like to be a consultee. Thank you.
And do the applicant have any objection to that being specifically referenced within the condition?
No, sir.
Okay, thank you very much. If we have no more comments on that, that brings us to the end of this item on the agenda. Before we move on to items 9 on 10, I propose maybe, because we've been at this for quite a while, maybe have a 10-minute comfort break if everybody's happy with that. So it's now 12:42. Let's say we're back at 5 to 1.
Or I don't know if anyone's got any lunch plans, or you prefer, because the likelihood is that this might take us till maybe 2 o'clock or so, but I don't know if anyone would prefer to have lunch or a short break. I think the option is for both are there.
A short break, please.
Okay.
Sir, none of Nature Scot doesn't have a view on the additional conditions proposed. It wasn't obvious that you would have questions for the Nature Scot team, and if that was the case, Nature Scot would prefer to step out at this stage. But if there is any potential for Nature Scot's involvement in these conditions, we would of course be happy to remain.
I think if we're going to take a short break, then I would ask that Nature Scot be present for a discussion on closing submissions. Now, I think we might be happy to take them in advance, but it would be useful just to get your views on that. But it may well be that there'll be matters coming up from the discussion on these 6 conditions that will require some discussions. But I could outline our plans for closing submissions in advance of item 9, and just to see if you had any comments on it in general, and then you could leave, I suppose. But I think it might be useful just so, because we're talking about timing of submissions for the inquiry that you're part of and such like. So if no one has an objection to that, we could have a discussion on closing submissions in general after we come back from a short break.
Of course.
Okay, I'll see everybody back here then at 5 to 1.
closing submissions then?
Yes, I think that would be a good idea. Yep.
Okay. Well, we've discussed a few matters today, but before that, there was an inquiry into the peatland impact, and there will be a necessity to have closing submissions specifically on that matter. Quite a number of issues today discussed with conditions. There are a couple of further written submission exercises that we have agreed that we will do as part of that discussion today. And there is also a unfinished business, if you like, with regard to policy matters, where we truncated the further written submissions on policy matters. So with all of that in the mix, our proposal is that we would write out in the form of a procedure notice and set out how we're going to deal with that, and make sure that the submissions are timed in such a way as that the closing submissions are submitted once everything is dealt with. However, I would suggest at least one matter that at the close of today, if everyone would be agreeable to the applicant making changes to the conditions, if you like, a revised table on the ones that we know are agreed, which would form a basis for other parties to comment in terms of further submission, closing submissions. So I think it would be useful to have a further iteration of conditions in order that parties can make their further written submissions. The timing of that, we'll have to wait and see how that fits in with the further written submissions. But in principle, are parties happy that the applicant could make amendments where they understand there is agreement, in order that they can make their closing submissions? We are likely to direct through the procedure notice specific matters that we would want comments on from certain parties on the conditions. But in general, are parties happy that the applicant is asked to prepare, if you like, an updated set of conditions, and that would form the basis directed by ourselves for closing submissions by the parties and then the applicant on conditions? Does that seem reasonable? The timing of which to be confirmed to fit in with other procedures?
Yes, sir, that does seem fair. In fact, Lizzie Tainch and I were discussing that in the break, and she's happy to do the hard work of doing it.
I was going to ask if she'd be so kind, so that's useful that you did the asking on our behalf. And on peatland impact, it's whether or not the timing. I think that the specific closing submissions relevant to the matters discussed at the inquiry may not be time bound by the other procedures. So the question was whether or not the two parties in that inquiry wish to deal with those closing submissions at an earlier stage, or wait until we get to the point that we can wrap up closing submissions for the whole inquiry. So I don't know if Mr. Trinick or Mr. Ferguson had a preference on that. We will be issuing a template asking you to summarise the details or your case in summary, and a specific closing submission on the inquiry topic. But is that something that you'd be happy to just fit in with the end closing submissions, or would you prefer to do that sooner? Mr. Trinick, any preference?
I prefer to wrap it all into one exercise at the end, because the submissions on peatland impact will link to submissions on policy, and I would want to make submissions on policy in relation to the peatland issue. I don't intend, noting where you're going, to make broader submissions on policy issues that do not relate to peatland, because you've got the material on that already. But I'd like your confirmation of if that is what you want, to focus purely on the peatland issues rather than make more general planning balance type submissions.
Mr. Ferguson, I'll come back to that with Mr. Trinick. Mr. Ferguson, do you have any comment on what Mr. Trinick has just said?
I agree with Mr. Trinick that it would be appropriate for closing submissions to take place at the same time as policy. So therefore, it's at the end of the process.
Okay. And are you in broad agreement with the concept of us setting out the process for that in the procedure notice, which will set out the further written submissions that we've agreed today, the applicant preparing conditions, and a timetable for the closing submissions, which will include the matters that were the inquiry and any other broader matters in terms of, you know, balance and such like. If we direct for specific things to be covered in closing submissions, we'll do that through the procedure notice. But I have, at the very least, policy matters with regard to peatland, the inquiry itself on peatland, conditions, and there may be other specific matters that we specify based on our review of all the material that's been in front of the inquiry, that we may require further submissions. That doesn't necessarily say that parties couldn't make other closing submissions, but that would be our we would set out our stall in that procedure notice. It won't be within the next 2 to 3 weeks because we have to go through these other procedures and things have to be done. So we will set out the timetable for that, and that's going to have an implication on when we complete our report. But I don't see any other way out of that. So, does the council have any concern with what it's heard about closing submissions? That will set it out in a procedure notice, just so there's no ambiguity, and then parties would be responding.
No, all sounds fine. I will make one request, I suppose, to the conditions. If you require a clean copy without tracks or any changes, we would request a copy with tracks and changes so we can focus our efforts on where amendments have been made. That's all.
We're content at this stage, where parties have been asked to comment that the tracks are kept on and explained, and we'll leave that to Ms. Tanish how to do that in terms of the existing table. But I think it would be useful to allow the applicant to update matters and narrate where the updates have been. We're not asking it at this point for a clean word copy, because it's clear that the conditions are not all agreed, and we'll probably do that when we come to preparing our own report, I think. So if everyone is generally, all the parties would get issued with a procedure notice that have been involved in the inquiry. There's not that many parties, so we'll copy it to everyone so you're aware of the timing and the process for closing submissions. I don't see anyone else with their hand up, so Mr. Bryans, I think I could hand back to you.
Okay, thank you. So that brings us to items 9 and 10 on the agenda, which I will just deal with together. So we will begin with condition 38, which is the implementation and the mitigation measures. Just noting that this is one of the onshore wind standard conditions, can I ask the applicant why they feel it doesn't meet the circular test? Can you build on your reasoning, please, with regards to necessity and reasonableness?
Yes, it's the applicant's view and the views taken by WGM and Mr. Trinick and other applications as well, that although it is appreciated as a ECU model condition, yeah, we agree it's not necessary. The mitigation measures as part of the application that are all necessary as part of the consent will all be otherwise are all specified specifically for each topic and each matter within the EIAR or any additional information or other documents that form part of the application. So there isn't, so in order to make the sort of condition acceptable, don't necessarily see that it requires an overarching condition itself to govern that. There are the specific conditions that are within the conditions table which govern the specific topics individually.
Thank you. And to the council, I know you made comment into this in your most recent submission, but would you like to make comment on it now?
Yeah, I can perhaps cover it. I think in our latest submission, we accept the applicant's position that if a consent is granted, it's granted, and part of that consent is the EIR and therefore the schedule of mitigation that's contained within. We have noticed in recent decisions that there's a mix of practices at the moment. Our preference is that if the condition is not included within the consent, that it is included within the annex description of development. So making it clear that the consent is the EIR, including reference to any supplementary information or AI, and reference to the schedule of mitigation contained within. Is common practice that we've had a finalised schedule of mitigation condition contained within a consent, which effectively means scope for additional mitigation that has been derived from working through the pre-start conditions to be added to that schedule of mitigation. So there's a comprehensive suite of mitigation that's clear for the consent after all the conditions have been worked through. In the absence of the conditioned approach, we don't see how that's feasible. It's a lot to digest, so.
Thank you. Mr. Trinick, I see you have your hand up.
Yes, so I've got a more fundamental objection to this condition. The way that I believe the system works is that for an EIA development, an EIR is published, which includes assessment of impacts and then mitigation, which can be either embedded or secured by condition in order to determine what the residual effects will be. Now, not all of those proposed mitigations are necessarily required, desirable, or reflected in consultee responses. So I believe that conditions, all mitigation should be explicitly set out in the Section 36 and the planning conditions, simply because not everything in the EIAR is either necessary or appropriate to take forward into conditions. My second objection is that simply saying that you do everything that it says in the EIAR and the AI is too vague to be enforceable. A lot of it is not very precise, and there's a lot of interpretation required, having looked at numerous schedules of mitigation in EIARs. Thirdly, I would certainly not agree with Mr. Wheeler. We put the whole provision in the annex. That makes it part of the description of the development and therefore not susceptible to a Section 36C or Section 42 process should there be a need to seek a variation. So I would certainly object to that. Those are my points.
Thank you. I'll give the council a chance to respond to that.
We're a bit concerned about what Mr. Trinick has just said. If the schedule of mitigation that's set in the EIR is not to be delivered on, that schedule of mitigation is critical to the findings of each technical chapter's assessment. So in the absence of those mitigation measures being secured, how can we rely upon the content of the EIR? We can't. So if we need a belt and braces approach, if there is no agreed schedule of mitigation condition, everything that's been tabled in the schedule of mitigation in the EIAR does need to be transposed into each planning condition. If that's what Mr. Trinick prefers, we can look to do that. That would seem the correct way forward.
If I may say, not quite what I'm saying. There are schedules of mitigation now required under the regulations to be inserted into the EIAR. As I say, firstly, not all of that mitigation will be determined through consultation responses and assessment to be ultimately appropriate or required. Secondly, and as a separate point I haven't made before, there may well be a conflict between the mitigation explicitly imposed by condition and that which is set out in the EIAR. That can easily happen and does happen. But what is proposed in the EIAR is taken forward in a rather different way and expressed as an explicit condition. This is why I feel that yes, it's an ECU standard condition, but I have to say I don't like it, and I don't think it's the right way to go about things, for reasons I've given.
Mr. Trent, you do seem to be arguing, though, based on the fact that you say that mitigation may change through condition, that clarifying what the mitigation is may be useful. You've obviously got concerns about the wording of just encompassing all the mitigation measures in the EIA report and popping them into the condition. But it did seem to me that you're arguing that having clarification on what the final mitigation is of use.
Well, yes, sir, that's the purpose of the conditions we're discussing today, very precisely, to secure the mitigation which is thought necessary, appropriate, and without which consent should not be granted. But that's the test of a condition, simply to try to incorporate what often vague promises, or at least promises which are not crystallized enough to be incorporated in a condition and therefore to be enforced, simply to incorporate all the mitigation set out in the EIAR is leading to that difficulty of precision and enforceability, and secondly, to, as I've said, a conflict between what was proposed in the EIAR at that stage, maybe 3 years before the decision is issued, and what comes out as appropriate from consultation responses and the drafting of explicit conditions. That's what I'm saying.
Thank you.
Would anybody like to raise any other matters on this one before we move on?
I think just to come back in, there is scope, obviously, within a conditioned approach to have a finalised scheme of mitigation, picking up on Mr. Trinick's point. The mitigation set in the EIR was at a point in time. Once you've worked through the AI and all of the conditions, that schedule of mitigation has moved on. It is only appropriate then for that to be finalised and secured. The absence of it being secured, I've got great concern about.
You've got my view, sir.
Thank you. Okay, I think we shall move on to condition number 39, which is site enabling works. Can I ask the council's view on the proposed inclusion of Part 1E of the tree protection measures?
Is it the council's view, just to double check?
Yes, please.
Yes. So,
sorry, no, sorry. The applicant's view on the council's proposed inclusion. Apologies.
Anyways, thanks for clarifying. Yes, so in respect of the council's request at 1E to include tree protection measures, reviewing that in conjunction with the council's comments at the last proposed condition, so condition 43, I believe, in respect of tree protection measures, and sort of cross-referring to those in the council's views. We're content for the tree protection measures to be included there on the basis that the separate tree protection condition isn't required at condition 43, and also highlight that the SEMP condition 12, part 2, P and Q also has relevant measures. So the SEMP condition has a felling plan, and then also there's tree protective barriers within part Q of that, which could be sufficient. So content to accept that on the basis that there isn't the required 43 at a later stage, which I believe the council agree with.
Thank you very much. Notwithstanding matters relating to the proposed requirement of the plan and monitoring officer, which we will move on to in condition 40, do any other parties have any other points they would like to raise on this condition? No? Okay. Let's move on to condition 40, planning monitoring officer. Given that this is a standard condition and taking into account the points raised by the council's recent submission, can the applicant please advise as to their view on why this proposed condition should be omitted?
Yes, sir. And again, this is a position that has been taken in respect of not just the proposed development, but other developments. It's looked at sort of on a case by case basis. The applicant agrees that a PMO and condition isn't necessary, and it fails the test of necessity and reasonableness. As we have further ahead in the conditions, we have the separate environmental clerk of works condition, which performs the monitoring and reporting role for those topics, and our view that a separate condition isn't required. As I mentioned in the conditions at the earlier comments, it wasn't imposed in Lime Kiln, and then in addition, the Cairnmore Hill consent that was submitted noted that it wasn't imposed. There wasn't a PMO condition imposed within that consent, within that application. Thank you.
Could I just add, sir, that noting the council's reference to a number of decisions in the 18th August comments, Cleanside, Corrigarth, to Bunloin, Craigreebach, etc. Only one of those projects went to inquiry, and therefore this sort of condition has only been tested at one of those, and that was Corrigarth 2. All the other consents were issued by the ministers following a no objection position taken by Highland Council. So the point being argued here was not tested in those cases.
Thank you. Do the council wish to make a comment in response?
I think just referencing the list of other cases, whilst there may be cases where there was no objection from the Highland Council and parties had reached agreement, it doesn't preclude the reporter from making their own judgment and decision on each case if they wish to do so. If they considered a PMO was not required for any of those cases, they could have quite easily taken out that condition. That is at their discretion, as I understand it. The other point I would just like to make is that this is a model condition set by Scottish Government. You'll be aware of the number of major developments that the Highland Council has to deal with as a region. In the absence of conditions such as this, it makes it particularly difficult to keep tabs with progress on the construction and build out on a number of major development sites across our region. If the applicant is suggesting it's double handling and it can be picked up within the other condition of the consent, it suggests that the provisions within this condition then get transposed into the E&P cow role, if that's the way we want to proceed.
Can I ask the council's view on one matter? We haven't got to the point that we're going to ask for all those decisions, the ones that we don't have. But would it be fair to say that apart from the final 3 decisions that you've listed out there, they would all have been taken before the update of the standard model conditions, where I believe the planning monitor officer condition, that's a new version of it, if you like. So the previous decisions, including Corrigarth 2, would not be based on the current version of the planning monitoring officer. Parties would agree with that, I assume, that's factual. And is it your understanding that that condition has been changed, it's been modified since previous versions of it, if you like, or previous decisions, that's a more up-to-date sort of a version that has been considered in recent decisions? Because as far as I'm aware, that there was changes made to it before it found its way into the model conditions. And I suppose what I'm asking is are these historic decisions before I think it's February 25, are they comparing apples and oranges in terms of conditions and what the requirements were? I don't know the detail of what was argued in Corrigan 2 in terms of the detail of the condition. They may have been asking for something slightly different.
I think there's potential, obviously, that because of the dates involved and the duration, time has passed. The standardised condition wording came at a certain point. Certain decisions will then have taken place post that. Without doing a cross-check and analysis, I wouldn't know precisely what amendments have been made. The point remains that going back decisions for the past 3+ years, that in principle, support for applying monitoring officer conditions has been carried forward by numerous reporters. I don't see any justifiable reason why this development should be treated any differently.
Any final comments, Mr. Trinick?
Well, I'm not sure the condition has been taken forward by numerous reporters, only in Corrigan, because the others did not go to inquiry. Other than that, and I don't know if there's any difference between the conditions we were discussing prior to the standard conditions or not. I really don't know. I do know that obviously we've been discussing this planning monitoring officer condition with Highland Council for a long time before the standard conditions came out. So that's all I can say.
Thank you, Mr. Trinick.
Okay, thank you. If there's not any other points anyone would like to raise on this matter, actually, just a small aside question. I note that in the footnote of this, the standard version of this condition, it mentions whether or not there are any other monitoring measures in place by the applicant. So is the proposal that this compliance with the conditions will be monitored elsewhere through a different role, or has thought been put into that by the applicant? What's your views on that?
Yeah, just sort of was confirming with Mr. Wild. So yeah, it's the ENCO. Yeah, would be providing the role.
Okay.
That's the footnote 24 in the ECU standard conditions, which I don't actually think are part of the documentation for the inquiry, but I assume everyone has got no objection to us referring to it. We would do anyway because it's in front of us, but we'll come on at the very end to updating the document list, but that may be one Mr. Ash could add to the document list without anyone being offended by that. So in making closing submissions, everyone has got access to that set of standard conditions, but it's footnote 24.
Yep, happy to do so. Just as an aside, Mr. Bray, for future conditions, would you prefer that footnotes are left in when preparing conditions overall? Or
I think those footnotes are really for guidance, as far as I understand, with regard to the footnotes. That particular footnote is about whether or not that condition should be applied. So that wouldn't be a footnote that would stay on, because it reads the condition should only be applied. No, sorry, should be applied unless it can be demonstrated that there are other reasons why it's not required or other measures in place for monitoring, etc. So it provides a bit of guidance rather than anything else to the consenting authority with regard to the requirement for the condition. So it's a guide on whether the condition should be imposed or not.
Noted, thank you.
Okay, we'll move on to condition 41 then, site inspection strategy. Noting the reasoning for the condition not being included, and specifically given the consent would be for 35 years, below the 40 years stipulated, again in the footnote for the standard condition. Does the council have any comments they wish to make with regards to this?
Just to refer to the model conditions reasoning for the condition is to deal with operational wind farms at year 25 and onwards. So there's a conflict in the model condition as it stands. So it's unclear to us if it should be applied for proposals for a period of 40 years or for a period of 25.
Does the applicant wish to make comment on this?
Yeah, so just considering the council's comment in reference to the project there, as Mr. Trinnick mentioned previously, there is a point that hasn't been tested within that. Also looking back at the report from the reporter for the Kalaki application, I noted that the council put forward a similar condition in respect of Kalaki, and the reporter specifically addressed that within his report. It's at paragraph 235 at page 39. And direct the reporters to there.
So to avoid confusion, the Kalaki inquiry report was one of those two submitted yesterday. You do have it, but there's no document number, obviously.
Thank you.
Okay, thank you. Are there any other points any parties wish to raise in this before we move on? Okay, moving on to condition 42, local employment scheme. Again, noting the council's recently submitted comments and the reason to include this condition, does the applicant have any further comments which they wish to make on this matter?
Yes, thanks, sir. First of all, let's just look at the reason for the condition. And the reason is to secure compliance with MPF4 policy 11C. I think it's important to have that reason in mind when looking at the merits of the condition. I am going to refer again as a starting point to the Kalaki inquiry report. And you might want to, do you have that in front of you? It's starting at electronic page 13.9, paragraph 241. Let me know when you're there.
Find it. Thank
Okay,
you.
thank you. That's where the discussion starts, and there's a record of what the council requested in 241, and the council's contention to be a sound policy and legal basis for the imposition of a condition. There's also a note in 242 that following the inquiry, the applicant contended the condition is not necessary to make the development acceptable or to ensure compliance with policy 11C. I move on to, in fact, paragraph 244, where the reporter, Mr. Reid, gave his views. He acknowledged there's no guidance in relation to assessing how to comply with policy 11C. He found in line 4 unclear how an applicant is to demonstrate whether any of the listed benefits will be maximised. It's not disputed there will be a level of benefit. It may be difficult to accurately quantify what the level of benefit will be to the local economy. Whilst the council's requested condition was set out the intent of the applicant to secure local benefits, it's not clear it provide a measure to establish whether any such benefits are maximised as required by policy 11C or that the condition is being met. I'm not persuaded that either of the proposed local employment scheme conditions may make any significant contribution in relation to making the proposed development more compliant with this criterion in relation to maximising benefit, therefore not necessary and not recommended to be imposed. Obviously that application was ultimately refused, so we don't know the views of the ministers on what the reporter said about that condition. Now, I've noted if you look at the council's comments received on the 18th, there's reliance on two decisions of the court. One, a decision of the Supreme Court and so binding in Scotland, the other not so. I haven't had much time to look at these, I have to say. And I've done my best, and I reserve the right to cover them further in closing submissions because of the time I've had. Looking first at the first case, which is the welcome break case, which you'll see noted in the second last yellow highlighted paragraph in the right column. The issue was whether the council had been correct to take into account, and I quote from the decision, but I'll do it in closing submissions, as a reason for granting planning permission, a series of obligations contained in Section 106, this was England agreement, which failed to comply with Regulation 122 of the SIL Regulations 2010. There are no such regulations in Scotland, which were consequently immaterial to the merits of the proposal. Now, the relevant paragraphs of that decision for you to look at are 44 to 53. And the point I make is that the context for this High Court decision, not binding in Scotland, was a planning obligation, not a condition. And very specifically, regulations not applicable in Scotland, the SIL regulations. Now, the obligation offered related to the supply of local produce to the proposed motorway service area. The judge didn't give a view on necessity for the obligation, as he said correctly that this was a planning judgment, and so one for the decision maker, not for the court. That's important. The judge did, though, find that if the offer which was made had more than a de minimis connection with the proposed development, it could be said to be directly related to it, materiality and weight again being for the council. And the court found that the offer fairly and reasonably related to what is proposed. Now, while that decision relates to the English SIL regulations, not to the circular on planning obligations, I can't argue that such a condition could never be lawful. I don't make that argument, whether offered as a condition or an obligation. I said the same at the Locklear inquiry, so I'm maintaining my position there. However, necessity is a matter for you and not for the court. You have to decide whether or not such a condition is necessary in order to enable consent to be granted. In my view, it fails the test of necessity for the same reasons that the Kalaki report has said, and therefore the condition should be rejected. I'm not sure of the relevance of the Supreme Court case cited by Highland Council, but no doubt Mr. Glendinning will explain it. The case, the Supreme Court looked at the question of whether a community benefit fund donation linked to a wind turbine was a material consideration under planning law. Not surprisingly, it said, no, it's not. We all know that. I'm not sure what that adds. Paragraph 55 of the judgment refers to the welcome break case, but it simply does that. It doesn't add anything either. But so I don't read the judgment as endorsing welcome break, and so giving a binding effect to that judgment. That's about all I can say, sir. Obviously, we would like you to reject that condition. Thank you.
Thank you, Mr. Chair. Just one point. I mean, although you've talked in a level of detail with regard to those judgments, they're not, as far as I'm aware, they may be in front of us, and they may have sneaked onto a list, but can I clarify with the council, did they submit those documents? Are they on the document list? I'm seeing people
not too sure they are. I don't think they are, however.
No, so it's difficult for us to take Mr. Trinick's evidence there when we don't have the documents. So the question to the councillors, council is, are you wishing us to consider those as additional documents to make a judgment on their kind of relevance and decide whether we accept them or not?
Yes, that would be appreciated.
So you're wanting to essentially submit these as part of the kind of documentation for the hearing. Does anyone have any objection to that, given their sort of providence, if you like, that's out with Scotland? Has there anyone got any objection for these documents to be submitted?
I don't think they take you any further forward, but I can't object to their submission. I don't. We'll deal with them in closing submissions. That's fine.
So when the council does, I think everyone's content, and on that basis, we would be no commentary. It's just the documents. You can leave the commentary until later. And I'm sure Mr. Tanish is adding those as potential documents to the overall list at the end. But when the council does submit them, we're not asking at this moment in time for any comments on it. It's just simply the submission of those documents. I don't know if we can have any more discussion on those documents because we don't have them. But sorry, Mr. Bryan, I was just jumping in on the documentation point there.
No, that's fine. Are there any other points any parties wish to raise on this matter? Yes.
Apologies, I was just going to add in relation to adding the two cases. I understand that a legal opinion was prepared by James Finlay KC, was previously lodged in another case involving the applicant and was referred to, which discusses these cases. And simply for completeness, the council would also ask that that be accepted in relation to this inquiry. I understand that my learned friend and Ms. Tayish have previously had sight of that too, and that been involved in discussions regarding that. And it's on the basis on which my understanding is the Kalaki decision was based as well with reference to that opinion.
Can I just double check what case that opinion was with reference to?
My understanding is that it wasn't prepared for any case specifically. It was more addressing the principle of the condition and the legality of the decision. However, it has been lodged by the Highland Council in several inquiries, including the Kalaki decision, which Learned Friends referred to.
Thanks for clarifying that. I just thought it was to do with a court case. Any objections from any other parties for that being submitted at a late stage?
I'm not sure what's going to be submitted. I mean, I do recall at Kalaki that James Finlay did put in, I think, a short note on legality. But for the moment, I'm going to object to its submission. What I would ask is that the council send Lizzie Tainch whatever it is they want to introduce, which we haven't seen, because it's another inquiry, another reporter, different case, and then we'll let you know, sir, if we object to its submission.
Yeah, certainly if there's not unanimous acceptance of it, we'd be reluctant to accept it today. So if agreement is reached, then if you can let us know. If not, then if you let us know and we'll make a decision on that. Sorry, Mr. Bryans, I was jumping in again on documentation matters.
Nope, that's you're perfectly welcome to. Any other further comments on this condition before we move on?
Just to reiterate the council's position that the condition is necessary to secure compliance with policy 11C. In the absence of any guidance on the policy, the council considers that the proposed condition is the only way to secure the benefits set out therein. The council's position in this, it does meet the policy test set out in circular, and understanding that Learning Friends accepted in principle the legality of the condition. So I just simply seek to reiterate that. In respect of the remarks which were made in relation to the two English cases which were referred to in the council's comments to the 18th of August, I think possibly that was picked up incorrectly in the council's comments with regard to the Supreme Court decision. So I apologise on behalf of that. It's not the case that we're saying that this approach was confirmed by the Supreme Court in relation to that set out by the English High Court in the Welcome Brave Group Limited case. So just to clarify the council's position on that. In relation to the Brave Group Limited case, and so far as that concerned, a planning obligation rather than a condition, I take on board the points that the Learned Friend raises. However, it's simply just cited with support to the principle that these matters could be relevant and have a sufficient connection to the proposed development in this case. So that's principally the reason why it's relied on by the council.
And you'll have your opportunity in closing submissions if the document is submitted to make those points. Sorry, Mr. Brown, I jumped in again.
No, thank you. Okay, I think we'll move on now to condition 43, tree protection measures. Can the council confirm that they are happy to drop this condition, given that the requirements can be addressed, as far as I can see, in the camp and condition 12, part 2Q?
Yes, that's council's position. Thank you.
Okay, thank you.
Sorry, just to come in, also to be covered in the enabling works condition as we previously agreed earlier on this morning.
Sorry, I didn't quite catch that.
Sorry, it's also to be covered in the enabling works condition as well that we covered earlier on in the session this morning. And on that basis, there's no need for this condition.
Okay, thank you very much. Any other points any parties wish to raise on this condition? Okay, that brings us to the end of item 10 on the agenda. Item 10 on the agenda. Are there any other matters in relation to conditions that any party wishes to raise today?
No, sir.
Okay, I see nothing. Mr. Bray, is there any other matters you wish to address at this point?
I think what we'll have to do is just clarify what has been agreed with regard to some of the submissions of documents. I'm sure they'll come in, but we'll seek to clarify that. We'll send out a procedure notice setting out the procedure for closing submissions, noting that it may not be as soon as you might have expected, because there are further written submissions to be gone through. And with regard to the revised and updated table of planning conditions, we wouldn't be expecting the applicant to prepare an update for conditions that are not agreed, if you like. So there are, I think, maybe the additional conditions. There's maybe a couple there that are not agreed. So we wouldn't be expecting an update there, but that would be a matter for further submissions. I think that's probably all I've got to say. I've also raised the matter of documents, and if all parties are happy that the applicant will liaise with the case officer to make sure that once all the documents are submitted, then an updated and finalised set of documents will be listed and sent out in advance of the first set, if you like, of closing submissions, so that everyone can make their closing submissions based on a full document list. And my final plea is I would not, or we would not expect or wish for any additional documents to be submitted as part of this inquiry. Whilst it may not be possible to exclude any eventuality, there's been a significant amount of late documents, which has been difficult to deal with and probably prolonged deliberations today. So we don't expect new documentation beyond which has been discussed. So hopefully you'll all take that as a reasonable warning, and anything that does come in is a matter of necessity. Mr. Bryan, so that's all I've got to say.
Okay, thank you. Well, if there aren't any other matters anyone wishes to raise, it just remains to me to say thank you to everyone for participating today. It's been very helpful to me, and I'm sure to Mr. Bray also, and I'm content that we've now covered the matters that we need to today. So thank you very much. Goodbye.